that it has been paid to the petitioner or to their predecessor. But that is a question of fact. But it can be ascertained from the records itself. So the two submissions are there, my lord, whether the land can be used bypassing the declarations under section 4 of the erstwhile act. Secondly, whether it can be used for any commercial purpose. Thirdly, whether they have to enlighten before the lordship whether the compensation has been paid when we have said it has not been paid. If it is not paid, the new act comes into play.
Where is your statement that it was not paid?
Read petition.
Paragraph?
Page number 19, para 30, your lordship. Also that आपने बोल रहे. This one, sir.
Page 18 also.
Page 8, ना, तो आपने बोले दिया sir.
Specific awardment in page 18. Compensation in regard to the majority landholding has not been deposited in the account of the beneficiaries.
Paragraph 30, in the manner in which it
You have not stated whether this includes you also.
Includes me. Certain judgments are also there with regard to the purpose of acquisition and thereafter differing from that, deviating from that. Certain judgments are there. I have not got that at this moment.
The state has not annexed documents showing payment of compensation?
No, my lord, I don't find.
Mr. De? Compensation was paid?
Lord, I am not coming with that brief, my lord. For that reason, I am not.
Paragraph 33.
Lord, your lordship fixed another date, my lord. I am asking.
Because the petitioners claimed that they were not paid compensation.
My lord, my lord, I am not the requiring body.
Petitioners are offered and
It
not
was acquired for
Next. My lord, kindly come to paragraph 33 of the writ petition.
Paragraph?
33, page 21. At the bottom, further, the petitioners contain, although the award was passed as early as in the year 1969, till today, neither the petitioner have offered and paid the compensation amount as per award in respect of the subject land, nor the compensation amount was deposited before the competent civil court as envisaged under section 30 of the old act.
And also 34, sir. Beta, আমরা extend করছি.
And 34 also I have repeated that.
So you say that the award was passed, but compensation not paid.
That
What
was
is your case? And physical position is also with you.
no,
not presently, not with us.
with us.
Presently with Asansol Development Office.
Position certificate is there.
You have stated here the physical position is with you.
No,
Paragraph
it is with the
33.
ADA.
No.
They have
We
stated.
have stated in our affidavit.
They have stated.
My lord, may I make one submission, my lord, in this regard? We are not the requiring body. We are not supposed to know whether compensation is paid or not. Actually, it was acquired by the housing department, and we have purchased it from the housing department. We are simply said a purchaser to make it a township, to develop it as a township.
That's commercial purpose.
Not for commercial purpose only. As a township means to provide housing facilities to under the act, under the Country and Town Act, Country and Town Planning Act, my lord. Under that act, ADDA is formed. Asansol Development Authority is formed, and under that act, we have acted for public purpose. Beside that, my lord, what they are saying, that compensation has not been paid, but the fact remains we are in possession. My lord, in this regard, may I cite, my lord, this decision, my lord, of Honorable Supreme Court. They are making out a case, actually, in the main writ petition, the case that has been made out is about deemed lapsing. The accusation has lapsed. It is deemed that the accusation has lapsed. That
No
is the case.
question at the moment because admittedly possession has been taken over.
My lord, kindly see.
So section 26(2) doesn't come into play at the moment. 24(2) doesn't
I'm
come into
just
play.
reading out the portion, my lord,
It is
290.
either payment of compensation or taking over of.
or taking both the factors, both the factors.
If either is done, then you do not get protection under this section. The other point which remains is change of user.
Diversification of use.
My lord, may I hand it over?
Number takeable.
223, volume 4, SCC
24, 370.
377.
কি আছে ওটাতে? জানি না আমি।
Citation টা
আমি বলতে পারবো না,
বলুন।
কি আছে।
This is settled law.
Settled. And also reiterated again, 223, volume 5, SCC 650. my lord.
The same
Same.
proposition.
Same proposition.
This is the same.
Paragraph 3 to 6.
Not required. This is settled.
3 to 6. So it is admitted the possession is with us.
Either of the two.
So the acquisition will not lapse. Even if they are not paid the compensation, the acquisition will not lapse.
No, no, I am not on acquisition.
Now he is widening his case, my lord.
No, no, that's not widening.
By filing rejoinder.
No, no, I am
supplementary,
not
he
widening.
is widening his
It is
case.
in my lead petition. That is, there is diversification of the declared.
Primarily, learned counsel says that there has been a change of user.
Exactly.
No, you kindly see the read
Purpose
petition,
has been
prayer
changed.
the prayer made in the read petition, my lord. The first prayer is an omnibus prayer. It includes everything under the sun. I'm not on it.
No, no, not worried.
The first one is an omnibus prayer. It includes everything under the sun.
The second prayer, I'm afraid, will not help you at the moment.
And there is no specific prayer or challenge that since you have changed the purpose, it is not for public purpose, so the acquisition will lapse.
If your lordship kindly come to paragraph P, prayer C, that
Act
covers
of malice.
prayer C. Yes, my lord.
It's omnibus prayer.
How can we deny that it is not an act of malice?
Malice, my lord, it should be treated in particulars. This is the malice cause.
This has to be explained by the state and the requiring body, I believe.
Yes, sir.
Since you are only the purchasers,
My lord.
the end users of it, so
Fine.
the explanation has to come forward from the state and the requiring body.
My lord, only that is the change of user. That is not my question. That is not depend on.
The requiring body has to
Yes, my
explain.
lord, requiring will show why it
Yes.
changed, whether there is any provision or not, or anything else, my lord.
Out of which
So that land has been sold out by you. Under what provision? Under what provision? Acquisition was for a different purpose.
দেখলাম বেঙ্গল সৃষ্টিকে দিয়েছে
By respondent number 4, yes.
বেঙ্গল সৃষ্টিকে দিয়েছে কোথায় দেখলাম
Yes.
ওহ, 2 নম্বর বলেছে 2 নম্বর
The further the total value of the land was 1.21 lakhs 67,020. And to the total of some of it is 58 lakhs, giving a balance of 13 lakhs 57,020. Something of 4. And it would give the value discount by 7 to RBI Calcutta and land. For housing complex. So the that housing department transferring and that other one.
This is not the dispute at all in the writ petition, sir, I'm afraid.
Well, the difficulty is this.
Where is the utilization in terms of the notification?
We have made the housing complex as use.
So how does the ADDA come into play into the picture?
We have already paid for that. The total value of the land.
You have sold out the land to the ADDA for commercial use. How is that permissible?
The housing-
বাবা সেই আইনটা দেখাও না, সেই আইনটা বললেই তো
They are the requiring body. They got the land from the government.
There is no dispute with regard to the fact that you got the land from the government. How have you utilized it? You have not made any construction. You have sold out the land.
No, we have made construction, we have sold we're making construction. So housing. Why shall it?
That is not the case of the ADDA.
Why shall it spend the land? We have made housing complex. It's the business of the housing.
No, my lord.
No, Lordship, kindly have it.
In this
doesn't-
regard, only one thing I would like to add in this regard to what my learned friend is saying.
Or decide
Well,
first.
ADDA, my lord, kindly appreciate that ADDA is not a private organization. It is an institute,
Yes.
it is a body created under the Town and Country Planning Act. And it is supposed to act for the benefit of the public. It is not a profit-making organization, my lord. Not a private organization, not a profit-making organization. So we have purchased, obviously we paid, but not for commercial gain. That is not that we have purchased it for 1 crore, we'll be earning 2 crore and making a profit of 1 crore.
Say you have purchased the land and made constructions.
We have given to for making construction for developing into under the Town and Country Planning map
But the
user.
housing board says
There is
that
a-
they have raised the construction.
No, I think,
We have not.
Please show me
think-
documents that you have raised construction. The other respondent is denying, is disputing your version, sir. You have the portion received by you. I'm not going beyond that. You say that you have raised construction there. The ADDA says they have purchased that land from you.
এরকম কথা বলছে। একরকম মুখে আসবে। এই শুনে আমি কি বলছি? এই তো সেটা বলছি না। এটা কি? এটা কি সরকারি সংস্থা?
সরকারি সংস্থা একদমই নয়।
Exactly.
But the price of the land was certain. Now the.
You are referring to documents which are not in dispute at all. You have received you are the requiring body, you have received it, you have paid the amount, no dispute at all. The dispute is after that. You say that you have raised construction. There is no document showing that you have utilized the land. The ADDA says you have transferred the land, you have sold out the land to them for a consideration. That is not your case at all. That is the dispute in the writ petition, sir.
I understand.
And you have filed documents which are all irrelevant.
No document that we have utilized the land.
Yes, where is that document? Because the petitioner alleges that you have not utilized it in terms of the section 6 declaration. That is the primary case of the petitioner. So how are you substantiating that? There is nothing.
Difficulty is what my
my lord, may I kindly fixes that another date. Mr. They also may come up with other more details, more papers to assist my lord.
Mr. They has nothing much to make to submit in this matter.
No, Mr.
It is
They,
for the housing board to substantiate that they have utilized it.
because he sold the
Because
land.
they say they have not sold it out to you, you say you have purchased it from them. That's the difficulty now.
I come up with more papers.
Please.
Though I have filed my affidavit, I have already filed my affidavit.
You have not been properly instructed, I'm sorry. You are harping on issues which are not in dispute at all. You are the requiring body, you have paid, that is settled. No dispute.
They have said they are handed over to Bengal System Infrastructure, to private bodies. On affidavit.
Private body for development under the act.
Have you explained that in your report?
My lord, No, my lord, we have not explained it in that way, but
That's the
it
only
is, my lord,
allegation against
we cannot do
you.
beyond that, my lord. We cannot go beyond the act because we have to follow the land user map. We
Please
have to
bring this-
follow the land user plan.
Bring this on record by way of an affidavit.
Land user plan, we have to follow it because under the act, we have to act.
Whatever you are submitting, please bring that on
That I will
record by way of an affidavit.
That I'll do.
Please come back with supplementary affidavits.
Well, in the
2
meantime,
and 4, both.
in the meantime, Lordship will kindly pass and any.
No, my lord,
restraint-
kindly sees that
Because the
compensation,
construction
deemed compensation has lapsed. First of all, and second of all, Bengal's history is not a party yet in this proceedings.
You have handed over, we have come to know from your
We have
affidavit.
disclosed, but they have not
Not
taken the
necessary.
trouble to make them a party.
Not necessarily to abide by the result of the repeat.
My lord, everything obvious. And
You
my
will
lord,
come back with a supplementary affidavit annexing the relevant documents.
my lord, to put an end to that argument of my learned friend that it has been lapsed, that acquisition has lapsed under section 24(2), my lord kindly makes that observation
To pass
because
a
again
detailed-
he will come up with that argument,
thing. So you have to pass a detailed order on that.
my lord.
The records are clear. And I don't think learned counsel will harp on that issue.
No, my
Rejoinder used by the petitioner to the report in the form of affidavit submitted on behalf of the second respondent is taken on record. Paragraph heard learned counsels for the parties. Paragraph. It is submitted on behalf of the fourth respondent that upon being made over possession of the plot in question by the state respondents, comma, the plot has been utilized by the West Bengal Housing Board by raising constructions therein. Stop. Per contra, comma, learned counsel for the second respondent submits that the plot in question has been sold out to the second respondent by the fourth respondent. And the second respondent has in turn, you have sold out,
My lord, we have handed over. That I have to make clear by way of supplementary affidavit. I will make it clear.
handed over the plot to
Bengal Srishti, my lord, that we have stated in the affidavit.
Bengal Srishti infrastructure.
Infrastructure. We have stated it. stated in our-
Bengal Srishti Infrastructure.
Page 2 of the affidavit in opposition.
Paragraph.
My lord, paragraph J, page 4. Bengal Srishti Infrastructure Development Limited. We have handed over the same along with other plots in favor of Bengal Srishti by way of memorandum
to
of understanding.
Bengal Srishti Infrastructure Development Limited by way of a memorandum of understanding
পরে হবে argument.
for raising construction therein. Paragraph, learned counsels for the second and fourth respondents seek to use
My lord.
if you succeed, everything goes.
Whatever submission I have,
25th September.
can you make it on instruction I have submitted? My submission.
That is what I've said, sir. You have taken all, I mean, you have been wrongly instructed. Instructions are not correct at all.
Particularly in the order sheet, noted on
হ্যাঁ
instruction.
বলেছে বলেছে
বলেছে।
What are on instructions? করুন?
So number 4.
Fourth respondent.
সারা তো বলছে কি জন্য
On instructions করবেন।
ঠিক আছে
সকালে হবে
সকালে হবে।
Much of.
I'm grateful to you.
মাছ অবলাই
25th September.
দাঁড়াও
Fourth কিন্তু fourth respondent.
স্যার
আপনার তো আমাকে লাগবে, আপনার নাম্বার
Next.
বলো তো, ফোন নাম্বার। এই দাদা, দাদা একটু বইটা দেবেন। মাই লর্ড, আই এম টেকিং ব্যাক দ্য বইটা, দাদা।
বইটা ফেরত।
আপনার নাম্বার কত?
Yes, the mentioned matters. Case 229, petitioner, you are appearing for the petitioner? Petitioner?
আপনি পিটিশনারে অ্যাপিয়ার জজকে জিজ্ঞেস
হ্যাঁ।
করছেন?
Yes, well, I'm for petitioner.
Yes.
I'm filing the evidence certificate. The petitioner initially filed an application for long-term money
Take
lease.
the microphone, please.
Yes. The petitioner initially filed an application for long-term money lease. That money lease having not been considered, moved a writ petition before the court. And my Lord Justice Soumitra Pal was pleased to direct the authorities to consider the same. And in pursuance to the said order, the authority granted money lease for 2 years. And possession was delivered, possession, physical possession was delivered, and possession certificate was also delivered. But my Lord, surprisingly enough, the before expiry of 9 months, the supply of challan was stopped. That is, my money lease became inoperative before expiry of 9 months. So, my Lord, I made an application before authority, without cancelling the lease, without giving me any opportunity of hearing why you have suspended money lease. So, that is, my Lord, my representation at page my Lord, answer 5, page 58. Followed by a reminder, followed by demand of justice by the land advocate. So, Miller, only I am humbly praying, let them consider why they have suspended without giving any notice and without, although there is a provision, in the lease deed that if the petitioner surrenders money lease, he will have to give 6 months notice. But the same also will be applicable in the case of the lesser. But that has not been done.
Where is your representation?
Yes, ma'am.
Where is your representation?
I can't hear now.
Where is your representation?
Page 58.
I'm not audible. You cannot hear me?
Page 58 followed by demand of justice in the next page.
Page 58.
58. And I say P, P5.
Let this be considered.
How is it possible, my lord? Repeating the deed itself is considered not maintainable, my lord. In the year 2012, my lord, he has applied for the short-term mining lease. A lot of short-term mining lease is, my lord, granted in favor of the petitioner. In the year 2015, these deed executed on, my lord, that is annexed P1, P2 for 2 years.
Till 17, that means.
That is expired. Possession handed over to him, my lord, your lordship kindly.
In 15. Page
54. Sir,
page 53, 54.
Page 54. Possession certificate. And he has received the possession. Next page, my lord. माननीय ATM DLL এর মাস্টার সাজেশন আদেশ বলে
Page 57 the চালান copy of চালান page 57.
স্যার আমি বলছি তো
হ্যাঁ বলুন বলুন
বুঝিয়ে পাইলাম possession has taken, my lord. So thereafter it has been expired and he has made representation in the 2021. There is no matter endorsement, no seal, whether it has been submitted or not. And after 2016, the concession rules might have come into effect. Therefore, it is not possible.
How do you explain the delay?
Well, kindly come to page
I repeat it, but
5, paragraph 7, my lord. They have not given me any notice, my lord. They are at losses. Without any reason and not without any notice. Stopped
Because-
my issuing a challan 9 months before expiry of issue.
No, Junior.
Well, I have made the representation. Let me consider why they have
স্যার বলছেন ডিলেটা কিভাবে এক্সপ্লেন করেছেন?
delayed the explain करने के. Nine months. Well, I made the representation in 21. I made the representation in
Your challan was stopped in 2015.
15, 16,
Your challan was stopped in 2015.
16.
By 16, 15 though.
This allegation prior to the expiry of the lease period, it is stopped 9 months prior to that.
They cannot whimsically stop issuing challan. They at least there is a procedure. They should give me notice. They should at least prior
Challan-
notice.
Challan was stopped in 2016.
Yes.
চালান 2016 বন্ধ
Yes.
হয়ে গেছে,
Yes.
জোরসে জিজ্ঞেস করছেন।
And you have filed your application in 2021.
Yes.
How do you explain the delay? From 2016 to 2021? Because in the meantime, the lease also expired.
Yes.
In the meantime, the lease also expired.
Malad, that responsibility is not my with me. They have approached the authority and he has assured that it will be considered, but they have not considered.
Have you stated that in your writ petition?
Yes.
Have you stated that in your writ petition?
Yes, similar. Yes, similar. I'm telling.
It's later also.
And petitioner. Okay. Huh? Nah. Then Malagana give me leave to explain my delay.
Since 2016 to 2021, you have not taken any steps.
Yes.
2016 থেকে 2021 অবধি আপনারা কোনো স্টেপ নেননি।
Malan, we had been to the office, we are assured, but the authority doesn't make any attempt to comply with my request.
Mr. Bandyopadhyay,
They should have done also. They have also duty. They have not considered.
Let the representation be considered, let the authority decide. Because I cannot hear him, he cannot hear me, it's very difficult. to compromise. Yes,
Next item, similar item, my lord. I have put this.
Similar না সেটা অন্য নেচারের একটুখানি।
Why not discussion?
the authority decide, let the representation be considered because
Well,
there is
there is-
authority decision.
He has made the representation for the SPLNL. He is also not the.
Well,
He might.
delay is considered dilutely. Here, well, 15 years delay was also considered. That is judgment of the our High Court Division Bench. Up to 15 years delay was condoned. Similar, only by innocuous prayer to dispose of my representation. Let them say, on the delay ground, I reject you. Let them say,
Just don't make the one of the proper authority. You have to make it to this.
ATM. ATM will consider.
yes,
ATM will consider.
Fourth respondent, let the fourth respondent consider.
ADM Bakura, ADM Miller.
You tell him, he is not able to hear me.
স্যার জসাই বলছেন এডিএম কে একটা দরখাস্ত দিতে তিনি কম্প্রিহেনসিভ একটা রিপ্রেজেন্টেশন তিনি কনসিডার করবেন।
Yes,
Yes.
affidavit of service.
আজ আবার জুনিয়রটা আসে না আবার। হ্যাঁ,
This is stated as assistant district magistrate, it should be additional. Respondent number 4,
Addition.
অ্যাসিস্ট্যান্ট দ্যাট ইজ অলসো রং অ্যাডিশনাল।
that's what I'm saying, that is also correct.
স্যার এইটা একটু ভুল আছে, এটা একটু কারেকশন করে দিতে হবে। এটা অ্যাডিশনাল ডিস্ট্রিক্ট ম্যাজিস্ট্রেট করে দিন, অ্যাসিস্ট্যান্ট।
Correct.
ডিস্ট্রিক্ট ম্যাজিস্ট্রেট।
হ্যাঁ এটা অ্যাডিশনাল হবে।
আচ্ছা,
অ্যাসিস্ট্যান্ট আছে, ওটা অ্যাসিস্ট্যান্ট হবে, অ্যাডিশনাল এটা কারেক্ট করে দিন।
আচ্ছা,
জসাই
আচ্ছা।
লিবার্টি দিচ্ছেন।
then I will do it.
Liberty, on prayer of the petitioner, liberty is granted to correct the cause title of the writ petition.
Additional district magistrate.
Paragraph.
Yes.
It is, huh? Wherein the assistant district magistrate and district land and land reforms officer be read as the additional district magistrate and district land and land reforms officer. Paragraph. It is contended on behalf of the petitioner that the petitioner was granted long-term mining lease in respect of the plot in question for a period of
পরেরটা হচ্ছে
deed of
মাইনালি
lease
ইয়েতে
dated
রিনুয়াল মাইনালি
20th February
রিনুয়াল
2015.
মাইনালি অর্ডার দিয়েছিল সঞ্জীব ব্যানার্জি,
And-
সেটা করেন।
Possession of the leasehold area was made over to him on 14th May 2014. Stop. The respondent authorities suddenly stopped issuance of challans before 9 months of expiry of the lease. Without assigning any reason therefore, or giving an opportunity of hearing to the petitioner. Stop. The petitioner approached the authority on several occasions seeking issuance of challans for the remaining 9 months of the lease period, but to no effect. Stop. The petitioner seeks to submit a comprehensive representation before the concerned authority in this regard and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the fourth respondent be directed to consider the representation in accordance with law. Paragraph. May I get a line code? It is submitted on behalf of the respondents that the lease has expired in the year 2017, and though issuance of challans was allegedly suspended in 2016, no step has been taken by the petitioner for resumption of such issuance till 2021, when the petitioner chose to submit the representation before the authority. Learned Counsel submits that the representation submitted by the petitioner be directed to be dealt with by the fourth respondent in accordance with law. Paragraph. In view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation ventilating his grievance before the fourth respondent within 2 weeks.
Yes. Within
2 weeks.
উইক্সের মধ্যে অ্যাপ্লিকেশন জমা দিতে হবে।
within 4 weeks. Take it 4 weeks.
4 weeks from date. Stop. The fourth respondent is directed to consider and dispose of the representation within another 1 month. Within 2 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of. Long term. Long term. Short term license.
Well, next matter, my lord.
স্যার ওইটাকে কারেকশন করে দেবেন।
And this and the-
হ্যাঁ ওটা করে দেবেন।
Well, I'm filing the evidence service. I'm also available for petitioner. And my lord, this is for renewal or application. The petitioner made application 6 months prior to expiry of the lease. So that was not considered. So the petitioner moved a rich petition given the Honorable Justice Sanjeev Banerjee, and his lordship was pleased to pass this order. Well, I'm analyzing by it is not legible. This is the order passed by my Lord Justice Sanjeev Banerjee.
অন্য কোনো ম্যাটার।
Sorry, sir. Number nine.
417.
Yeah, I got it.
8417.
Ah,
এটা নয়, application।
এটা নয় তাই না? না, এটা একটা আছে।
হ্যাঁ, সেটা দেন, ওটা পরে হবে।
না, এটা কা দিলাম।
8417 দেন, এটা ঠিক না। এটা বের করুন, কি আছে দেখি। হ্যাঁ, এটা দেন। এটা দেন।
ওইটা একটু ভুল হয়ে গেছে, ওটা পড়তে হবে। I communicated this order to the concerned authority of my Lord Mr. Justice Sanjeev Banerjee as his lordship then was. That after receipt of this order, they are sitting tight and they are not taken any step. This is, my lord, at page
What is your prayer?
yes, I'm telling. এটা না, এটা তো ভুল হলো এটা।
এইটা না না, এইটা তো।
এইটাই তো সমাপদ না
বাবা, ওটা নয়, এইটা।
এটা হচ্ছে তাই না? হ্যাঁ,
এটা প্রেয়ার পড়ুন।
আচ্ছা, fair না।
প্রেয়ার আমি বের করে দিচ্ছি।
দেখি
আপনাকেও তো ইয়ে করতে হবে না।
রিপ্রেজেন্টেশনটা দেখি।
পড়ুন প্রেয়ার।
Lord, my prayer is, Lord, a mandamus commanding the respondent, now 3, the district magistrate Bankuda, to execute lease deed এটা না, এটা কার এটা? To execute lease deed, এটা একটা অন্য একটা হচ্ছে এটা। ওটা কি এটা একটা আলাদা এটা, ভুল হচ্ছে।
আরে ওটা নয়, এইটা 8517 এইটা
817 না, এটা ওটা তো অন্য মাটা হচ্ছে 8438।
8417 তো।
না না, এটার নাম কি আছে নাম?
8417.
আপনি কি চান তাই বলুন তো?
শ্যামাপদ নায়ক।
My representation to be
এইটা রিপ্রেজেন্ট ভালো রিপ্রেজেন্টেটিভ করছে না।
Where is the
না
representation?
এটা কে?
এই আমার
না না দেখছি দেখুন দেখুন,
এটা
এটা
শ্যামাপদ নায়ক।
ওটা ভুল হয়ে গেছে।
দেখছো, এইটা
আপনার এটা হয়ে গেছে, ওইটা।
দেখুন তো,
He's not assisted by a junior.
we are all juniors.
এইটাই তো।
আপনি কোনটা করতে চাইছেন? আর একটা আছে শুভাশিস,
ওটা দেখুন,
ওটা হয়ে গেছে,
ওটা হয়ে গেছে।
ওটা হয়ে গেছে ওটা।
মালার that is the page 66 এইটা তো রিপ্রেজেন্টেশন অসীম কুমার হাজরা।
অসীম কুমার হাজরা,
হ্যাঁ, মালার that is page 66 বাবা ওটা টাকা
শ্যামাপদ নায়ক।
এটা রেখে দেন না, এটা রেখে দেন।
হ্যাঁ,
করে টাকাচ্ছে।
Page 65, annexure P3,
Yes, my lord.
P3,
re-execution,
Yes, my lord.
re-execution of lease.
P3 66,
হ্যাঁ,
page 66।
66।
then
হ্যাঁ,
There is no 66 in the writ petition.
65, my lord.
এখানে 66 করেছে।
মানে আছে original. It's a
P3
execution of date of final lease deed of
What does this mean?
well, the lease was executed, but it was 125, 120 days delay. That is why the registration office asked that you will have to press execute. So that we have went before the district magistrate, he has not done. The lease need to be executed by the district magistrate. Fresh.
File an application and that will be considered.
By whom?
But they have already,
That is the medium or
not district magistrate.
District
District magistrate will execute this deed.
So that let this representation be considered. How is re-execution permissible? I do not
my
know.
lord, that is considered his representation. Whether that will be another time.
Affidavit of service. Paragraph, the petitioner seeks a direction upon
120
the
delay.
district magistrate Bankura, comma, being the district magistrate is not a party.
শ্যামাপদ নায়ক, এরপরে একটা আছে,
তার হবে না, ওটা আজকে হবে না।
হ্যাঁ, ওটা হয়ে যাবে আজকে।
এটা বলে
He has not been made a party. Let him be added as a party. Please add the district magistrate as a party.
Yes.
Yes.
yes,
Affidavit of service এর পরে করুন, on prayer of the petitioner, liberty is granted to implead the district magistrate, comma, Bankura as respondent number
this one number
8,
Huh?
8 in the writ petition. Stop, the cause title of the writ petition be amended accordingly. Paragraph, the petitioner seeks a direction upon the eighth respondent to consider the representation submitted by him
এটা হচ্ছে এটা consider হবে কি এটা?
on
এটা
পরে এটা নয়, এটা হবে।
ওটা হয়ে যাচ্ছে তো, পত্র করে দিন।
no date also of the representation.
Yes.
Date of representation, no.
আজ করে তো বলেছি তো। আচ্ছা, স্যার। My lord, that is 15th February.
15th February 2021.
Yes, ma'am.
On 15th February 2021. Uh, 2021, requesting re-execution of deed of lease in his favor. Stop. Paragraph, learned counsel for the respondent submits that the eighth respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the eighth respondent to consider and dispose of the representation submitted by the petitioner dated such and such. Within 1 month, Mr. Dey? Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. The decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of by chapter 9. আরেকটা আছে না, করে দিও না।
In the next matter, will say same order. Representation to be considered.
You are
And
appearing.
dated 7/1/16.
Who is appearing?
Next matter.
Let it be disposed of. Who is appearing?
পরে করবেন
Affidavit of service.
দাও আমি করবো।
Affidavit of service. to the-
Page 30.
File.
The order of Justice Sanjeev Banerjee has not been complied with. That I made a representation. Page 30.
Mr. Dey. Affidavit of service, none appears for the respondents despite service. Mr. Dey service regularized. I'm regularizing your service. This is also for?
Page 20,
No, page 30.
30, madam.
Page 30, representation dated 7/1/16. Similar here,
That four lines
Justice
representation.
Banerjee order has not been complied with. There is a direction from the Honorable Justice Sanjeev Banerjee, but they have not considered. We filed it in due time, within 10 days. That is still pending. Justice Banerjee passed an order on 14th
District magistrate is.
December 15.
party. Yes, third respondent. The petitioner seeks
কোনটা?
a direction upon the
কবি নেই?
third respondent
দিয়ে দেবো।
আমি ছিলাম না।
আচ্ছা,
to
আচ্ছা।
consider his representation submitted on 27th January
অন্য কোনটা দিয়ে দেবো এখানে?
2016, comma, in compliance with the uh, 2016. কি বললাম সেন্টেন্সটা বলুন? For renewal of his mining lease in compliance with an order passed by a coordinate bench of this court. Court on
হ্যাঁ, দিয়ে দেবো।
December 14, 2015 in WP 29389 within bracket W of 2015. Stop. Paragraph, learned counsel for the respondent submits that the third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the same, in view of the above, the writ petition is disposed of, directing the third respondent to consider and
নামটা
dispose
লিখে
of
দাও।
the representation submitted by the petitioner dated such and such. Within 1 month? Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law.
ঠিক আছে, পেনটা দিয়ে নামটা ঠিক করে দেয়।
এটা করে দিলাম।
এটা না,
In accordance with law.
অরিজিনালে।
অরিজিনাল করে দেবে, লিখে দিলাম।
এটা সঞ্জীব ব্যানার্জি অর্ডার এটা।
থাক আমার কাছে।
হ্যাঁ, ওটা থাক।
In the light of the observation, in accordance with
দেবো,
the-
দেবো, দেবো।
in the light of the observation made by this court in the order dated December 14, 2015. Stop. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of which act.
This-
254.
Contempt. The file টা দাও। My lord, may I take your lordship to page number 21?
It's appearing for the first time.
No, my lord. It's appearing for the third time.
Sir,
They have served, they have filed affidavit of compliance.
it's appearing.
My lord, Mr. Debrai was appearing on the last occasion.
I have complied with my lord's order, my lord.
My lord, it was not complied with.
Agree. He can refer further petition.
No, my lord, that is not the issue. Order has not been complied with. May I take your lordship to page number 21?
Pursuant to the order. Wrong heading. Page 5, Annex A.
Give me a minute, please.
My
A fresh letter was directed to be issued.
My lord, strictly on the terms as set out by this honorable court. My lord, the terms were mentioned, and in the page 22, last paragraph, Special Secretary to the Government of West Bengal, being respondent third herein, is directed to issue a fresh letter to the Director Transport, being respondent number 4 herein, in strict compliance with the order set out herein above. My lord, that was the strict word has been used. My lord, may I take your lordship to the so-called affidavit in compliance?
Yes.
My lord, the page number 5 is the letter. My lord, subject word has been omitted. Your lordship's order was subject to being different and distinct. Subject word has been omitted by the director himself, despite there is a specific direction.
In terms doesn't mean. in
Strictly means, my lord,
Substance, it has to be the same.
my lord, the order has to be,
Not be used.
my lord, in the letter, similar letter has been issued, which was earlier issued, which was set aside, my lord. My lord, the exact terms which were mentioned in your lordship's order has to be needed to be mentioned in the letter, my lord. That was the purport of the your lordship's order. My lord, the strictly terms has not been mentioned in the letter of compliance. My lord, two terms are strictly set out by your lordship, my lord, which is at page number 21 of the solemn judgment order passed by your lordship. That was not mentioned. Only number has been changed to show that they have complied. That is the issue, my lord.
Sorry.
The order has been.
নম্বরটা চেঞ্জ করেছে অথরিটি, কিন্তু অর্ডার কমপ্লাই করেনি। তো অর্ডার এসে দেখুন পেজ নাম্বার 21-এ ওইখানে টোটাল অর্ডারটাই কমিউনিকেট করার অর্ডার ছিল, যা সেট আউট করা ছিল কোর্ট থেকে। কোর্ট
It
তো
has been stated in a different language. It has been complied.
Yes, fully complied. Yes,
And also being different and distinct from the category of vehicles it's stated.
My lord, may I take your lordship to page number 21 of your lordship's order? I'm reading the
language
purport.
is different. They have not
My lord,
copied it.
I'm reading the purport, my lord. There was, my lord, there was,
intention is very much clear.
My lord.
Let him try. Yes.
my lord, may I take your lordship to page 21?
Yes.
The relevant portion of the letter dated 16 November is set out in the order to ascertain whether said letter in compliance with the order passed in the writ petition. My lord, direction is from third para. Accordingly, writ petition is disposed of directing the Director, Transport Director, being the sixth respondent herein, to issue necessary direction upon the concerned regional transport offices to grant registration to e-rickshaw manufactured by the petitioner, subject, my lord, subject to the said vehicle being different and distinct.
That is stated in the letter also.
My lord, subject word has been omitted.
Not necessary, sir. Please understand the purpose
My
of
lord,
the
my
letter.
lord, thereafter, my lord, at page number 22, my lord,
Yes.
the relevant portion of the order passed in WPA 21621 of September 27, in view of the observation made by the Honorable Division Bench, this court is inclined to hold that writ petition may be disposed of directing the respondent to consider registration of vehicles manufactured by the petitioner, subject to compliance of Rule 126 of CMVRs, and upon taking into consideration all the relevant document to be produced by the petitioner at the time of registration. My lord, this clause was also not mentioned. Only rule 126 was mentioned. Second term was not mentioned. Accordingly, writ petition is disposed of, directing the fifth respondent to consider the registration of e-rickshaws manufactured by the petitioner in terms of order of Honorable Division Bench.
Yes, this second part is not mentioned, Mr. Devroy. The first part is mentioned, second part is not mentioned in the letter.
Page number 22, sir. আগেরটা। পার্টটা মেনশন নেই। রুল 126 টা করা আছে, এটা মেনশন নেই। টা করা আছে কিন্তু এর পরেরটা করা নেই স্যার।
Upon taking into consideration all relevant documents being produced by the petitioner at the time of registration. That's like that
Yes,
line on the
yes.
committee.
That is not stated. Even compliance of rule 126 is not there.
স্যার এখানে
I do not understand why the director has such difficulty.
No, there
It
is
is-
no difficulty.
It is set out in the order.
Just complied with my lord's order. My lord.
It is set out in the order. Only that has to be set out in the letter.
Has to be.
Please come back with an affidavit of compliance. This is not compliance at all.
My lord, my humble submission to that effect, my lord, order in rem in toto, which has been passed by the Honorable High Court, has to be mentioned. That is the main thing which has been directed. এখানে স্যার কাইন্ডলি একটু পেজ নাম্বার 23 টা দেখবেন
Need
স্যার।
not be mentioned in toto, but the substance should be the same.
My
Substance
substance
Two
also.
No, these 2 points are missed out. Please come to page 22.
Subject are- Page 22.
The paragraph in italics, that is not in the letter.
In view of observation.
Yes,
স্যার এটা পরিষ্কার।
subject to compliance of rule 126 and upon taking into consideration all relevant documents. These are not recorded. These are not stated in the letter. It has to be stated. Yes. So this is not compliance. Please instruct Mr. Devra, please instruct your authority to send letters. This is not a difficult task at all.
No.
In terms of the exact language written in both the pages, 21 and 22.
Fine.
It is submitted on behalf of the applicant petition. It is submitted by the applicant petitioner in person. That the order under contempt has not been complied with by the alleged contemptor.
বাধ্য।
Paragraph, learned counsel for the alleged contemner seeks accommodation to comply with the order under contempt in its entirety and submit an affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on 11th September.
Some more time we require.
Only a letter has to be issued, Mr. Devroy. No adjudication, no determination, nothing.
I will do it.
They have to see these 2 pages and issue a letter, that's all.
I will.
Next day, if it is not complied, I have to call the director.
No. Definitely.
11th September.
Great.
11th September. My.
257 is also the same issue.
My lord, it was on the, my lord, same issue, more or less same, my lord.
Next one.
Oh, next matter, the same order may be passed.
In 257,
Same, my lord. Only 2 contempts are there. They are analogous files with the contempt. Under the contempt heading, 2 contempt applications are there. Both are more or less same, my lord.
এটা কি আছে? আমি তো
আপনি থাকুন না স্যার, করিয়ে দিন কমপ্লেন।
আমি করে দেবো।
কমপ্লেন্স করিয়ে দিলে তো প্রবলেম নেই।
here report has not been filed.
I not appear.
Yes, you are appearing. On the earlier date, you wanted to take instructions.
স্যার আপনি করিয়ে দেন, একটা হ্যান্ডে থাকলে কপি দেওয়া আছে, আমি আরেকটা কপি দিয়ে দিচ্ছি আপনাকে।
কপি দিয়ে দেন।
ঠিক।
Learned counsel for the alleged contemner seeks accommodation to comply with the order under contempt. Paragraph, same date. Let the matter appear under the same heading on 11th September. Paragraph, affidavit of compliance be submitted on the adjourned date. Yes, Mr. Debra. Private respondent, you're appearing.
And I have already
Exception has also been filed.
on the last occasion, sir. But the facts is that the petitioner and the private respondents are the two uterine brother. The private respondent, the hold a permit. It is intended to be transferred in the name of his brother. Now he made an
The name of the petitioner.
his brother is a petitioner. He made an application. Now, during the course of pendency of the application, the vehicle has to be transferred in the name of the petitioner. In course of these procedures, the time has expired. Now, he made a representations before the authority. And on the basis of prior to that, decision has been adopted by the authority in favor of this transfer that your lordship will get from page, that is, I'm not traveling, there is a page 21 of my writ petition. It's second.
Yes.
B. Now, a decision in on the next page.
Yes.
Now, I made an application for renewal. The lordship will find at page 24. And in the meantime, the vehicle which has been transferred in.
It was allowed or approved on certain terms.
My lord. Similar, the application for renewal also made, my lord, on your lordship will find at page 24 of my writ petitions. Now, my lord, the page 25 is the application, my lord, rather, my lord, the applications for renewal of the permit and the vehicle to be endorsed in the permit. My lord, the first page, my lord, page 24.
This is renewal of permit and replacement of vehicle.
Yes, that vehicle has to. Now, the page 24. It's an important thing. My learned friend raised these objections and filed the report on that. Page 24, your lordship will find this is a computer generated copy, and this copy has been supplied by the authority itself. This is a specific format, but there is no format at all in respect of renewal or replacement. There is no format. Now, it has been supplied because of the facts. I have taken this point because of the facts. The old file, which has been the entry of the old file, to be computerized in a new format. Your lordship will find at the top of this particular format, format for backlog entry. So, the file which was earlier mentioned in the file of their file, that has to be entered into the computer. For that reasons, this format has been supplied by them. But the allegations which has been taken
That the only allegation is that this format which has been signed by Manjit Singh. Number the Manjit Singh till my lord transferred actually, but physical transfer is made. The Manjit Singh cannot be made an application for renewal or replacement. Number that is there, and it is found that my lord the applications they supplied the copy that is signed by Garmel Singh. In their report, in paragraph, this is the main allegations, I think, in their report in paragraph 11.
Yes.
It has been taken, the point has been taken, it is only after a lapse of so and so period, so and so, which has been received by the office, the answering respondent by docket number so and so, a copy of applications is annexed. In their report, they annex the copy of this format. The next, they have stated, it would be pertinent to mention here that from a bare perusal of the application for renewal bearing R2 annexure 2 present in the present affidavit, it transpired that the applications were submitted by respondent number 5, that is private respondent, before the office of the respondent. However, from the annexure P3, that's my writ petition, to the writ petition, it seems to such applications was made by the writ petitioner before the respondent STA. Thus, it is apparent that the petitioner has produced a forged and fabricated document pertaining fraud practice upon this honorable court in order to obtain a favorable order. So, this is in exception, but I have replied to that. This is these main allegations over and above. Maybe Lordship kindly take my exception and kindly come to the paragraph. Yes. Paragraph 8 and then paragraph 9. Paragraph 8 with reference to the contents, para 10, they are para 10. They reported, affirmed the so and so, deny dispute, whatever be, the permit was valid up to such and such. And as per the decision within the validity period up to, petitioner pay for renewal of permit. At the time of renewal of permit, the order of the transfer of ownership might be affected to the replacement of which the vehicle has been. Now, dear Lordship, kindly come to the next para 9. With reference to the contents of so and so, so and so, my reply is that the allegations 7x or others, the principal officer ST West Bengal blamed that the respondent number 5 solely stating to renewal of a permit, be it was mistake of on the part of the respondent, is a plain paper. Next page. Now, your Lordship, kindly come to the next paragraph where I have specifically taken this point. কোথায় রে আমি কোন প্যারাগ্রাফে বললাম না আমি এখানে বলবো অ্যাপ্লিকেশনসটা যেটা বলছে kindly bear for a moment. No, my lord, sorry, my lord, your lordship, kindly take this paragraph 5. Paragraph 5 with reference to the contents in so and so, every allegation. Then with reference to the contents made in paragraph 5 to 8 of the report affirmed. Now, your lordship, kindly see
Paragraph 6, yes.
Yes, there paragraph 6. There, the principal officers of the STA narrated the facts and incidents which is happened earlier. I am not denying those incidents, not denying that the respondent number 5 is not any my uterine brother, some so and so. Then, my lord, with reference to the paragraph so and so, my lord, your lordship will find that I have stated. Kindly bear, my lord. কোন প্যারাগ্রাফটা আমি বললাম সবগুলো না তো বলেছি প্যারা 6.
You've just read para 6.
কোথায় গিয়ে বললাম তো ওটা ব্যাকলগ বলেছি কোথায় দেখা দিচ্ছিস বলছি প্যারা থ্রিতেও বলেছি and also my lord I'm sorry my lord para 3 and the para 3 sub para that I have narrated this one with the facts. I say that only your also it starts from the validity, then the I have stated the renewal permit, the office need to record the data in computer under electronic system. The permit petitioner submitted a printed form for backlog entry in respect of old file number so and so as required and supplied by the officer STM, which I made 2 copies prior to filled up the same, one of which signed by myself and another copy was signed by the respondent number 5 being my uterine brother. Now we'll also kindly come to the next paragraph, sub-para. I say that 1 copy of the form which I submitted at the receiving counter of the respondent authority was the copy signed by the respondent number 5, my uterine brother, and the copy which the respondent acknowledged by putting their seal and docket number is the copy which bear my signature, which is evident from the docket number itself. Number appeared in both the applications on which they are annexed in the report R2 and the copy which I annexed in my writ petition being P3. But the docket number are same.
And there is no conflict between the petitioner and the private respondent.
That is the that is one aspect of the matter. There is no, because they are the uterine brothers. Now, but the only thing is this is the allegation I have categorically stated these are bona fide mistake. And if your lordship kindly ask me, then I can produce the seal with original docket number. That is not the Xerox one. There they received in my copy of the signature there is. But this is not a case that in between ourselves there is any.
What
So
is your
that cannot be a fraud practice upon the court to obtain a favorable order from my lord.
prayer?
The prayer is that to renew the permit and enforce the replaced vehicle. That is not the only prayer. Prayer কোথায় গেল? তো কোনটার উপর and that on the basis of the resolution or the decision adopted by the state. And request.
There has to be a renewal first and then a transfer.
The
Permit has to be renewed first. It has
the
expired.
permit has to be renewed on the basis of unless there is a vehicle. Vehicle has to be
Place.
placed therein. So the vehicle has to be placed and the transfer has to be made in favor of the petitioner. Then it can be only first the placement of the vehicle. Then my lord, it has to be renewed.
Then
it-
the transfer. Yes. But what about the vehicle?
Yes, ভেহিকলটা কোথায় দিয়ে দিয়েছিল নাকি? ভেহিকলটা দিয়েছি কোথায় কোন প্যারা কোথায়?
Annexure R4 of.
Yes. The vehicle has been annexed করেছিস তো এইটা না?
This is the main thing.
এইটা তো কোনটা এইটা your worship will find at page 18. Page 18, the vehicle which has been already transferred in the name of the petitioner.
Page 18.
Page 18 of my writ petition. This Xerox copy of the smart card. Will also page 18. এটা মনজিৎ সিং এর নাম। তা এখন কোথায় দিয়েছিস সেটা কোথায়? সেটা তো বলছি বারবার। Now, this is the old vehicle which was there. It was transferred in the name of the petitioner.
Now you'll go for a replacement.
There is also that I have also annexed. Your lordship will find at page 28.
Page
28.
28, yes.
The certificate of registration. It is in the name of my lord, the Manjit Singh. Your lordship will
This is
find.
the transfer.
But this is not that, this is not that vehicle. Your lordship will find the number WB 57B 6146. But the top, your lordship will registration number. Now your lordship earlier because number is different.
So now you seek renewal.
My lord.
Now you seek renewal.
A renewal and the placement of this particular vehicle.
Upon
That is not
placement.
yet, endorsed in the
Upon placement of vehicle.
upon placement. This has been already, well, that I purchase and I get it transferred in my name is a new one.
And it is in principle approved.
That is that the decisions taken by the ST. এই ওল্ড বিলটা ওখানে ওখানেই রয়েছে পারমিটেই রয়েছে yes
Yes, Mr. Debra.
2017, the 17 March 2017, the transfer has been sanctioned by the authority. Thereafter, 5.5 years lapsed. Now they came and say that renewal and transfer with a BS3 compliance vehicle. BS3 compliance, that is, my lord, lordship kindly see the regulation of the ST, my lord, page 10 of my report.
কোথায় বলেছে
Henceforth, no new interstate plan, lordship, what is
Give me a minute.
page 10, part 3 of my report.
ওইটা দেখাতে বলেছে
Page 10, yes.
yes
Henceforth, no new interstate permit and placement of vehicle with countersign if the vehicle does not possess pollution norm less than BS4. He has to challenge first. I cannot override the policy.
This is in 2022.
Yes. 2017, if 2017 come, then my lord, renewal has been made by BS3. But after 8 December 2022 cannot. There are several circular also. Lordship knows 2nd June also there is circular.
এটা আমার কাছে ছিল কখন তাহলে কি বলেছে আমি রিপ্লাই কি বলেছি
His vehicle is my lord, lordship kindly chief, R4 and page 11,
Yes.
RO stage 3. 1, 2, 3, 4, right hand column. RO stage,
Yes, yes.
that cannot be part.
Yes, Mr. Mukherjee.
now my lord kindly come on the page 24 of my writ petition
Yes.
but it has been this has been submitted subject to my lord's correction 2022 now will your lordship kindly come 22 September I will lordship kindly come to the decisions which are now I will in the report itself never ever handed over this now my lord, this has been annexed with the report now they are saying these decisions taken on December 2022 had it been a case it has been decided by at least October 2022 because my application was of September 2022 well, this is one aspect of this matter the other aspects your lordship yesterday also decided another way the decisions and the guidelines which has been framed by the government as of today then that has to be placed because there is no only it has been given the preference it has to be the encouragement has to be given to the operator so that they can place the vehicle of such and such model this is not a mandate when I have yesterday I have produced that decision the
At least of the same model.
yes that is there earlier was the That was non-BS, but
Uh,
that was not BS at all.
Mr.
That was
Speaker,
even given there, Malad. It is a replacement also,
this
and that has been
resolution
specific.
gives a prospective effect.
My lord.
It says henceforth. In any case, resolutions are of prospective nature. Doesn't give any retrospective effect.
That cannot.
This is from 8th December 2022. It says henceforth no new permit will be, no interstate permit will be replaced or granted.
Counterside.
But the application
And
was
that-
pending prior to that.
September 20.
Yes.
Then, my lord, subsequently, 2017 transfer was sanctioned.
Second, my lord.
After 5.5 years, he come before this court.
Is there any limitation?
5.5 years, he cannot, my lord. After 5.5 years, same position is there.
Is he debarred under the law?
No, that is lordship knows.
If he is not,
That is not.
he can come.
So lordship kindly.
And moreover, my lord, the route never ever fallen within the KM area also. This is up to the Asansol.
Also restricted zone.
So that is not the guideline says,
Also restricted zone.
but the guidelines which has been, my lord, published by the Transport Department yesterday, I have shown, my lord, that is in respect of KMA also. But this is a route completely outside the KMA because it's terminated at Asansol. And the, my lord, also, my lord, at least that should be the BS1. Earlier one, not the BS7. These are BS3. Earlier one was not the BS, which has been intended to replace. That was not a BS also. So
Will
Bharat,
that-
yes, this is a Bharat stage 3, but that was not a Bharat stage. In any pollution norms are not there. September. সেপ্টেম্বরে দেওয়া হচ্ছে এটা সময় এটা তুই এটাই দেখো না যেটা তোমাদের কাছেই আছে সেটাই তো সেপ্টেম্বর
Let this joint representation be considered.
That is better.
Yes, anything to add? Yes, because you are sailing in the same boat with the petitioner, so you. Yes, yes. Heard learned counsel.
May I take the Miller minutes?
The petitioner and the private respondent are uterine brothers. And the private respondent transferred the vehicle being WB 37B 3152. That was the vehicle of the private respondent. Page 18. WB 37B 3152. In favor of the petitioner. Stop. The permit granted in respect of the said vehicle was valid up to 17th March 2017. The permit was valid up to 1st November 2022.
My lord,
Yes,
page 15, my lord. Renewed up to handwritten, my lord. Renewed up
the
to
valid up to 1st November 2022. Stop. Since the vehicle completed 15 years of age as on 13th December 2022, the vehicle was sought to be replaced by a BS3 compliant vehicle bearing registration number WB57B 6146.
My lord.
Registered in the name of the petitioner. Stop. The petitioner submitted an application before the concerned authority seeking renewal of the permit upon placing the upon replacement of the earlier vehicle. The petitioner filed an application for this. Authority on, open the date. It was in September 2022. The application doesn't bear a date.
My lord, it was annexed with the catalog entry, my lord,
Yes, but what is the date of
on
your
same date,
application?
on same date,
Same day,
same date.
on 9th September 2022. Correct. Seeking renewal of earlier vehicle, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Stop. Learned counsel for the petitioner takes this court to a resolution of the RTA board, STA board, taken in its meeting dated 17th March 2017, wherein the joint application for transfer of permit submitted by the petitioner and the private respondent was taken into consideration, and it was decided and the board approved the said transfer subject to the transferee producing a vehicle legally owned by him within the valid period of within the validity of the permit. Stop. It was also recorded that the vehicle should be compatible with the prevalent pollution norms. Stop. Placing reliance on the report in the form of affidavit submitted on behalf of the respondents, learned counsel for the respondents draws the attention of the court to a decision taken in a board meeting held on 8th December 2022 to the effect that henceforth no new interstate permit and replacement of vehicle will be countersigned if the vehicle does not possess pollution norms less than BS Roman 4. Stop. Also, learned counsel points out that the that though the private respondent / permit holder applied before the authority for renewal of his permit on 9th September 2022, the document annexed to the petition reveals that an identical application was also made before the authority by the petitioner on the same date. Also, it is only after lapse of almost 5.5 years that the private respondent has applied for renewal of his permit. Stop. Paragraph. একটা কেটে দিন তাহলে। Paragraph. The resolution taken on 17th March 2017 demonstrates that upon clarification being made by the petitioner and the private respondent, their request for transfer of permit was approved by the board subject to certain conditions. Stop. It is a fact that 2 separate applications were made by the petitioner and the private respondent before the authority for renewal of the permit. On the same date, in respect of the 3152 is the earlier vehicle.
My lord.
In respect of the earlier vehicle. The private respondent, having consented to transfer the permit in favor of the petitioner, submission of 2 separate applications does not indicate any malafide on the part of the petitioner. Stop. The resolution relied upon by the respondents, the resolution dated 8 December 2022 relied upon by the respondents is prospective and the application for renewal of permit was made by the petitioner and the private respondent on 9th September 2022, comma, that is, comma, prior to the said resolution. Stop. Therefore, such renewal is not governed by the resolution taken on 8th December 2022. Stop. Moreover, comma, the resolution is with regard to counter signature of permits and not issuance or renewal of the same. It refers to only counter signature. Paragraph. Since the private respondent is willing to transfer the permit in favor of the petitioner and the petitioner is ready to replace the earlier vehicle by the later one, comma, this court is inclined to hold that the concerned authority, secretary should consider, Mr. Debra, the secretary should consider, being the fourth respondent herein, be directed to consider the application submitted by them in accordance with law. Paragraph, the petition is accordingly disposed of, directing the fourth respondent to consider and dispose of the application submitted by the petitioner and the private respondent jointly within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner and the private respondent, and in the light of the observation made in the body of this order, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of the judgment.
I'm good.
Not a petitioner? Active? Identity of cause of action for the next.
May I submit, my
Lord, I appear for the petitioner, my lord. On last occasion, my lord, there was initially the direction upon them to submit a report. So far as railway is concerned, my lord, I have received it today, my lord, and my lord, my learned friend was also directed to. This is with regard to, my lord, the
may I submit report, my lord? My report.
Proceed on the basis of this report, right there. Then I have no objection.
Let him come back with an affidavit.
my lord.
Please come back with an affidavit.
My lord, there will be a direction upon to serve at advance
Yes,
copies.
please serve, yes, please give him an advance copy. Report in the form of affidavit submitted on behalf of the South Eastern Railways is taken on record. Paragraph, learned counsel for the state respondent seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 15th September.
Great.
And I am for the petitioner, and apropos your lordship's last direction, my lord, a report has been.
My lord, I have filed an application for addition of party, my lord.
Oh,
Let it be.
Have you received a copy?
no,
My lord, I will serve a copy. I have filed it today, my lord. My lord, today itself I filed. My lord, may I serve a copy? Sir, a copy.
This is the report, Mr. Devra. Please serve copies.
I have served copies, my lord. Today itself I have filed, my lord. I am an interested stakeholder in the, my lord, in the whole thing, my lord. I will be affected adversely, my lord.
and may I come with an opposition to this application, my lord?
Yes, the proposed intervener files an application for addition of party in the writ petition.
Can number
The
one.
application is not in the can one of
Can number one.
the application being can 1 of 2023 is not in the file. Paragraph, the department is directed to put up the application along with the file on the adjourned date. Paragraph, learned counsel for the petitioners seeks to use an affidavit in opposition to the application
And my lord, an exception to the report filed by Mr. Dev Roy.
and an exception to the report in the form of affidavit submitted on behalf of the state respondents.
Lordship.
এটা কি বলেছি আমি? Report in the form of affidavit আছে কি বলছে? একদম শুরুতে নিয়ে নেব। Report in the form of affidavit শুরুতে নেব। Paragraph, let the matter appear under the same heading. Please serve copies, sir.
I have served, my lord. I will serve the other respondents.
20th September,
Lordship.
Grateful, my lord.
20th 20.
Sir, নামটা নামটা
Yeah.
এক সেকেন্ড
Yes, my lord. I beg to appear on behalf of the respondents.
Milord, I appear for the petitioner, Milord. There is a direction to file report, Milord. What I understand, Milord, today morning they have sent it to the email through my advocate on record, who had not come, but my learned friend and the president have sent another mail to me right now, Milord. I'll be seeking, Milord, sometime to, Milord, get back to.
Where is the physical copy?
Yes, my lord.
You want to come back? You want to come back with an exception?
Yes, Milord, I have not even able to see, Milord. Just now she has been, Milord, only one thing, Milord, the interim order will expire tomorrow, Milord. There is an
No, my lord. I am, my lord, my lord, subject to lordship's kind sanction. With regard to the interim order, my lord, if your lordship kindly sees once, my lord, the report filed by me.
Prior to that, you should have served a copy
My lord,
earlier.
that is my,
If you are so agreed with the interim order.
Lord,
let
I
it be
know.
extended for a.
I know.
for a
Lord,
limited
my lord, I
period.
know. I cannot say that with what is,
Should have been served earlier.
but next
Report
week,
in
my
the
lord,
form of affidavit submitted on behalf of respondent numbers 2, 3, and 4 is taken on record. Paragraph, learned counsel for the petitioners seeks to use an exception to the said report if required.
Yes.
Report, comma, if required. Stop. Paragraph, let the matter appear under the same heading on 13th September.
lordship, I am great.
Paragraph, the interim order granted earlier is extended till 30th September or until further orders, comma, whichever is earlier.
I am
Grateful.
grateful.
Next.
I'm being on behalf of the petitioner. But I am the manufacturer of e-rickshaw. And also, my lord, same order was passed, my lord. I annexed, my lord, memo number 13 January,
State.
page number,
Where are you?
page number 48, 58,
একটা স্টেট কেও দিয়ে দিই কপি স্টেটের কাছে থাকে না
page number 58, and page number 125, my similar order was 128, just day before yesterday. 125, 13.
my lord similar order may be passed my lord My lord, at page number 2, para 1, my submission has been recorded. My lord, I most humbly pray for reflecting the page number where from this submission I have mentioned. Page number 77 of this writ petition.
Not necessary. Why?
My lord, my humble submission may be taken on record. This is my humble request, my lord. Kindly, my lord. Page number 77, this interference has been drawn up.
77.
Page number 77 is also your submission.
My lord,
It is
no,
your
my lord,
submission, there also it is your submission. What is
my
the
lord,
difference?
from there only,
You are making- it is
from
not
that,
the
from that
observation of-
order, my lord, if your lordship kindly read the page 77. No, I am
I
not
have seen page
incorporating.
number 77. The first line
My
is your
lord.
submission.
First was my submission,
Yes.
and thereafter on that basis, this submission has been taken by your lordship.
Not
My lord,
this
that's why,
basis.
my lord.
Even if you would not have made this submission earlier, it could have been
Same letter.
recorded.
My lord, may
This is
kindly,
not
my
an
lord.
observation of
Only-
the court. It is
No,
not
I am not,
necessary at all.
my lord, I am not, my lord, my submission may be recorded. I am
Your
not,
submission has already been recorded.
my lord, page number 77
Not
may kindly.
necessary, not necessary at all. It is same order to court. It's being disposed of by the same order.
My lord. Biblio. In
এটাও mention করে দিন তো।
Next,
Similar matter.
follow item number 271 identical, same matter. Mr. Sinha,
This is
India,
262.
another court. 271 same matter. 271.
have to call one by one. I'm
ঠিক
marking
আছে,
it.
আছি আমি।
I'm marking it, 271. Let it be called.
Call.
Rajiv, 271 or same order, একটা note রাখো।
Well, I am appearing on behalf of the petitioner in this matter.
একটা note রাখুন, আপনি যদি চলে যান, আপনি order করবেন।
I am for the private respondent, my lord.
Yes,
Petitioner has challenged
আমি বলছি না।
for implementation of one.
দেখো, আজ petitioner আমি তো, তুমি দাঁড়াও।
বলে দিই স্যার।
তুমি কি
We are
বলবে?
asking for implementation of one resolution adopted by the regional transport. I have challenged that resolution. My lord has fixed the matter on 19th September, my lord. The day before yesterday, the matter was
let
taken
both
up.
the matters appear together.
Yes, both the two matters appear analogous.
Decisions Otherwise,
You challenge,
he is challenged.
but no copy was served upon us.
The same resolution was challenged.
Same resolution.
No,
And you
no
have
copy
not
was served upon us.
not
No copy
made
was served.
petitioner
Because
a
we are
party.
affected, because both the education was called for hearing.
Have you made them a party?
No, my lord, I have not made them party because I have challenged the resolution of the RTA.
So they-
Only
they are
what
affected.
happened, my lord.
But
they-
that decision was taken after hearing both association affected. Kindly see the decision. Kindly see the decision.
Let the matter appear on the same day. Please implement.
Kindly see the said decision. Kindly see the said decision.
Mr.
Man, kindly
Paul,
see
let
the
both
page
the
of 49.
Let both the matters appear on the same day.
Yes, yes.
Otherwise, there will be conflict of
Yes,
decision.
I agree with man.
I am giving the writ petition number of the another 12778.
The number to the
These parties on the next date,
Yes, yes, my
give
lord.
them an advance copy. We can take up both the matters
So
together.
advance
Not
copy
waste
দিয়ে দাও।
time unnecessarily.
আমাকে দিয়ে দাও।
It is submitted on behalf of the private.
On an
respondent.
earlier occasion that this matter was also adjourned on that prayer.
No, no.
তুই সেই দিন বলে দিতে পারতে তো।
The petitioners,
তো এই ground
এখন নাম্বারটা দিয়ে দাও।
implementation
resolution challenge হয়েছে।
of the resolution of the RTA board taken on 12th April 2023. Stop. Paragraph learned counsel for the private respondent submits that the private respondent has filed a writ petition challenging the said resolution. Can you give the number of the writ petition?
Petition নাম্বারটা
WPA
Has filed a writ petition, ওখানে being WPA
ওই যে লিখে দাও।
12778 of 2020.
12778 of
Yes, ma'am.
2023.
Yes.
Which shall appear
Kindly fix short date because matter is pending since long.
on 19th,
19.
on 19th September. It is already appearing on 19th September.
Yes, yes.
19th
Paragraph, let this matter
19th September.
appear under the same heading on 19th September. In view of that, let this matter appear under the same heading on 19th.
If
64,
on this matter, I am appearing on behalf of the petitioner. Mr. Debra is appearing on behalf of the state respondents. I have served the copy to upon all the respondents. State of Jharkhand also I have served the copy.
Yes, what is the matter about?
Well, here in this case, my lord, initially, my lord, can you see the page number 22? Page number 22.
Yes,
But this is the interstate route. Initially, permit was issued in the name of Horizon Rai.
yes,
And later on, my lord, after demise of his father, the permit was transferred on serial number 3, left side, transferred to Sri Pulograi, my present petitioner.
yes,
But this permit was issued in the year 1968, that's 55 years ago. And this permit was renewed time to time. And my lord, counterpart, that is state of Bihar before bifurcation. And after bifurcation also, state of Jharkhand also countersigned time to time. And lastly, my lord, this permit was renewed, my lord, at the top, my lord, left side, renewed up to 5th May 2023, with effect from 5th May 2018. My lord has got it.
yes,
Yes, yes, yes.
yes,
Now can you see the page number 27? When a permit was issued in the year 2068, then my lord, that time, my lord, no, there is no agreement of interstate agreement. First time, my lord, agreement was both the state, that is state of West Bengal, state of Bihar, entered into the reciprocal agreement in the year 1976. And relevant portion, page number 33,
this is a draft agreement.
draft agreement, they are the final, later on final, these are. Well, this route, page number 33, Chatras to Raniganj, page number 33, the Chatras to Raniganj.
Yes,
This route was introduced, and the quota one for each state. That my quota, permit was issued by the state of West Bengal in terms of the quota of the people of the state of West Bengal, and that permit was continued till 5th May 2023. Now, my lord, page number 37, another subsequent agreement was executed in between the two states of state of Bihar and state of West Bengal, 1988. Then, my lord, this route was also included in this notification, page number page number 44, serial number 82, running us to Chatras.
it's not legible at all. This
It
page.
available, it was Chatras. The type of this then. Now, my lord, after bifurcation, page number 53. After bifurcation, the reciprocal agreement was executed in between the state of West Bengal and the state of Jharkhand.
Yes,
Now, permit was renewed time to time, and till, my lord, 5th May 2018, permit was counter signature. Thereafter, permit was renewed, but till, my lord, which was valid till 5th May 2023. Last 5 years, my lord, state of Jharkhand did not countersign on the permit on this whole ground. Now, can you see the page number 66?
yes,
Right memo dated 215. Secretary State Transport of Jharkhand, type copy, left page number 67 type copy. Secretary State Transport of Jharkhand wrote a letter to the Secretary State Transport of West Bengal, relevant that the subject matter regarding counter signature of permanent permit PST number such and such in respect of route from Raniganj to Katrasgarh in favor of permit holder Sri Pulak Kumar Rai Asansol, with regard to the aforesaid subject and reference to your letter dated 6th April 2018 in this regard, it is stated as underneath. The said permit in respect of routes from Raniganj to Katrasgarh issued as PSTB number such and such West Bengal in favor of Sri Pulak Kumar Rai Asansol was earlier countersigned by the authority for period 5th May 2013 to 4th May 2018. Thereafter, the permit holder again applied for countersignature of the said permit from this authority for next 5 years with effect from 1st May 2018. In the sequence of countersignature, it was found that the said route Raniganj to Kathrasgarh is not included in the reciprocal transport agreement signed between the state of Jharkhand and the state of West Bengal. Therefore, in light of the aforesaid situation, the countersignature of BSTP number such and such, the route Raniganj to Kathrasgarh is not possible at this end. You are requested to clarify the context of the basis of the renewal of the said permit so that it can be done according to the rules. Now can you see the reciprocal agreement which was executed between the state of West Bengal in the year 2004, page number 53. Kindly come back. Relevant portion, page number 56. One of the condition, general, the clause 8, sub clause F, page number 56. My lord has got it.
Clause 8, subclause.
Clause 8, sub clause 5. If any change or correction in any clause of the agreement or any addition or deletion of route or any correction change in the alignment route shown in the reciprocal transport agreement may be done by the mutual consent after discussion. For this reason, State Transport Authority of Jharkhand requested to give the consent to clarify the context of the basis of the renewal of the permit so that it can be done according to rules. All that was not done. And permit was renewed. But permit, I cannot use the permit because unless the permit is countersigned by the other counterpart, I cannot ply the vehicle. For this reason, a writ petition was moved, page number 68. A writ petition was moved before this honorable court, before the other coordinate bench, and the relevant portion, page number 69. The other coordinate bench passed the order directing the Secretary, State Transport Authority, last paragraph, page number 69. In such situation, direct the Secretary of the State Transport Authority of West Bengal to take all steps required as was requested by the Secretary of State Jharkhand and to issue the result of development in this regard to his learned advocate. For such exercise, I grant 8 weeks time from the date of communication. This order to the Secretary of State Transport Authority of West Bengal. The matter is urgent. Now, pursuant to the direction of this honorable court, page number 72, the state of Jharkhand, but direction upon the State Transport Authority, this silence, no decision has been taken. But State Transport Authority, Jharkhand, at least 2 occasions, sent a reminder and requested to give the consent in terms of the clause 8, subclause F of the agreement, to give the consent to include, for inclusion, the aforesaid route Raniganj to Kathrasgarh with 1 quota for West Bengal, 1 quota for Jharkhand, page number 72. But the State Transport Authority silence. Thereafter, my lords, in the meantime, my permit has already expired. Before expiry, long time, on 4th May 2000, 4th April 2023, I made an application on Bahon Online, page number 86. Page number.
Yes, this is for renewal.
Yes, sir. Page number, my lord. 77. No, 77.
86.
Sorry, 82. Online. Application on, at the bottom, 8 April 2023. Thereafter, other undertaking is given there, and also made a representation. Page number 86. Requested the State Transport Authority to accept my application fees and to renew the permit. After receiving this, I've been asked to pay the taxes because tax amount that is 75,000, which was calculated by the authority. I have already paid the tax 75,500. But no steps had been taken for renewal permits. So kindly direct the Secretary of State of West Bengal to take steps in terms of the memo, page number 72, because other counterpart requested for inclusion in the agreement for this route with one quota for West Bengal, with one quota for Jharkhand, so that ST Jharkhand can countersign in the permit. And as in terms of the clause 8, sub-clause 8, and also my lord made this representation requesting to accept the application to renew the permit. Because last 55 years, well, I'm continuing the permit. There's no problem. Only the state of Jharkhand, my lord, requested because this route is required to be included in the because interstate route. Permit was countersigned. But from since 18 to 2023, permit was renewed. I have paid the tax, everything, but I could not use that permit due to no countersign. So kindly direct the authority to take steps in terms of the memo dated 7th December 2021, page number 72, which was issued by the state of Jharkhand. And so direct the Secretary of State to consider this representation, page number 86, and to accept the fees and to renew the permit. And I have paid the taxes also, but can you see 75,000 I have asked to pay. Just listen to 2 or 3 days back, I paid the taxes 75,500.
Yes. Jharkhand.
Page 86.
72,000 is the Jharkhand request.
86, that is the last representation made.
Yes.
I don't know why they are silent. In spite of the by the Jharkhand authority. Where also the agreement, in case clarified, Lordship indicate that the decision is taken in the light of the agreement, because 8F, there is an order passed by Justice Gangopathy also here. I have seen this. So, Lordship will direct and fix the time secretary, not deputy.
No, Secretary of State, not deputy.
Yes, yes, madam.
Lordship, let them consider the representation, your lordship, which he has made.
The reciprocal agreement is 2004.
Yes, your
You
lordship.
have renewed till 2018.
Lordship, now it has been pointed out that the route is not included in the
It was
agreement,
not
your lordship.
pointed out earlier.
Okay.
2004 to 2018. Acquiescence.
Without inclusion in the agreement, permit was countersigned time to time.
That's what I'm saying.
Right.
Yes.
Affidavit of service. It is contended on behalf of the petitioner that permit was initially issued in favor of the petitioner's father, Haridhan Roy, since deceased, and thereafter transferred in favor of the petitioner. Stop. Petitioner issued in Haridhan Roy in the year 1968. Since deceased, in the year 1968, and was stop. The permit has been renewed from time to time and was valid up to 5th May 2018. Stop.
One thing I interrupt, sorry, man, extremely sorry, man. I interrupt. Man, Lordship will direct them, they sit together.
Yes.
Jharkhand Authority and STF West Bengal sit together and decide the issue first. First his route is be included, then renewal is.
That has to be done in.
That has to be done. Why they have to keep it silent, I fail to understand.
Page number 72. গাড়িটা ট্যাক্স দিয়ে দিচ্ছে সে গাড়িটা না
Second
ওটা থাকলে না ঠাকুর
The permit was countersigned by the respondent number. By the STA Jharkhand,
yes ST Jharkhand.
by the STA Jharkhand, comma, being the fifth respondent herein up to 2018, stop. The said authority refused to countersign the permit of the petitioner thereafter on the ground that the route Raiganj to Katrashgarh,
Raniganj.
oh, Raniganj to Raniganj.
Katras.
Raniganj to Katrasgarh, Katrasgarh. Katrasgarh was not included in the reciprocal transport agreement signed by and between the two states.
These words included in the earlier notice. পরে আবার 88 হয়েছিল সেখানেও ছিল 88 হয়ে ওটা তো ফাইনাল এগ্রিমেন্ট 88 হলো সেখানেও ছিল
ঝাড়খণ্ড দিয়ে হলো
সেইটাই তো সেইটাই কাউন্টার করে যাচ্ছিল এখন ভুল ধরা পড়েছে তো এবার ঝাড়খণ্ড বারবার রিকোয়েস্ট করছে তুমি কনস্ট্যান্ট দাও
I'm still pending.
The The State Transport Authority, comma, Jharkhand, comma, by a letter issued on 7th December 2021 to the State Transport Authority West Bengal, requested consent of the latter, LATTER, on the point of inclusion of the route Raniganj to Katrasgarh with one quota of Jharkhand and one quota of one quota to Jharkhand and one quota to West Bengal of two crore
in the reciprocal agreement.
in the reciprocal agreement. The petitioner submitted a representation before the STA West Bengal on 10th January 2022. No, on page 86.
And
What is the date
last
of your,
representation 17th April.
what is the date of your representation? 17th April.
17th April, page number 86.
On 17th April 2023 করুন data. Requesting renewal of his permit.
The application was submitted on the online.
On the basis of application submitted by him online on
4th April, 5th April, and they put it. At the bottom, my lord, 5th April 2023, at the bottom.
On 5th April 2023.
2023.
Stop. Paragraph. Learned counsels for the respondents submit on cells, huh? For the respondents, submit that both the STA West Bengal and the STA Jharkhand be directed to sit together and take a joint decision with regard to inclusion of the route Raniganj to Katrasgarh in terms of clause 8 capital F of the reciprocal transport agreement between the states executed in 2004. Stop. Paragraph.
In the agreement, it is the word through correspondence. We can read her also.
Yes.
Through correspondence in between the two states. What about it? They take this?
Let them consider. Yes. Paragraph. It is strangely enough. Paragraph. It is strangely enough, comma. The STA Jharkhand continued to renew the continued to countersign the permit of the petitioner till 2018, despite the route not being included in the reciprocal agreement executed in 2004. Stop. Be that as it may, comma, since both the authorities consent to inclusion of the said route in the agreement in terms of clause 8 capital F of the reciprocal agreement, comma, the writ petition is disposed of, directing the
Secretary STA respond 3 and respond number.
The Secretary, State Transport Authority, comma, West Bengal,
And also
comma, being the third respondent hearing, and the Secretary, comma, State Transport Authority, comma, Jharkhand, comma, being the fifth respondent herein, to act in terms of the letter issued by the
page number 72.
fifth respondent
As well as
on
80th
7th
of-
December
As well as
2021,
80th of the agreement.
as well as clause 8 capital F of the agreement, and dispose of the application
Page number 86.
for counter signature submitted by the petitioner and the representation dated 17th April 2023 within 1 month,
1 month.
1 month.
Text this.
within 1 month from the date of communication of this order. Hearing is necessary, no?
Hearing is necessary.
Hearing must.
Upon
Because
affording reasonable opportunity of hearing to all the interested persons, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authorities shall be communicated to the petitioner within a week thereof. Disposed of, which are clear.
Obliged.
Deep local.
And I beg to appear for the respondent. Led by Mr. Soumitra Bandyopadhyay.
Petitioner,
I am appearing for the petition.
yes.
Kindly skip over to page 23, annexure P5. But the overlapping of the time, my lord, the petitioner has applied for consideration.
Have you served the private respondent?
Yes, yes, they're appearing, all.
Who is appearing for the
Private respondent, I'm appearing with the state respondent, led by Mr.
Where is the service?
The service to go to private respondent.
There are two private respondents.
I'm appealing for.
For both the private respondents? Yes. Page 22?
Page 23,
Yes.
where the authority be directed to consider this representation and to pass a reasoned order. Upon hearing,
What are you asking for in the representation?
sir, I am asking for fixing of the time of the two buses. Because one of the bus of the petitioner, before that only 15 minutes in advance, the bus of the private respondent runs. That's the problem. I think where the problem can be sorted out if the authority concerned convene the meeting, my lord.
My lord,
Hearing taken.
hearing taken,
আপনি নিজেই বলেছেন
P5,
Reputation-
নিজে ডিসকাশন হবে।
Hearing হয়েছে?
Reputation-এ বলেছেন, hearing taken, no decision passed.
This, my lord, the petitioner never annexed his permit, neither the timetable. Your lordship.
What has happened in the hearing?
My lord, what has happened in the hearing, that has to be ascertained. My lord, the notice of the hearing has been given and they have duly appeared in the hearing.
You've appeared in the hearing.
Appear হয়েছিল?
They annexed, they appeared in the hearing.
বলো
Page?
Page 22, P5. Hearing notice.
The hearing notice is there, but I am
The
told.
notice.
He appeared.
আমি জানি না।
It was fixed on 14th March. Have you appeared?
Appear হয়েছিলিস?
Can't help. You received notice. It is your notice.
Yes, yes, I can't, but I am told that no,
So if you have not appeared, you cannot seek any further relief.
well, may I take proper instructions because I am told otherwise.
Please do that.
My learned friend is saying other thing,
No, no, because you have annexed the notice.
জানি দেখেছি আমি
Kindly come to my prayer.
And let learned counsel come back with instructions. Because this is
They are
contradictory.
asking for setting aside something which has not been annexed yet. But your lordship kindly see prayer A and prayer B.
Where is the proposed timetable?
টাইম টেবিলটা তো নেই,
দুটো আছে,
দুটো আছে।
একটা দেওয়া আছে।
উনি crave করেছেন, উনি crave
But that is at page 20, one table is there, page 20.
This is the proposed timetable.
And another is at page 18. এই তো, 18 and 20.
These are two timetables of myself.
Two
Well, may I-
timetables of?
May I pray for one thing, my lord?
600, your lordship.
I myself is puzzled, my lord, with this.
19/7/2022.
Let me
That
take
has
proper
not-
instructions from my juniors, my lord. Any date be fixed.
Please do that.
Yes, yes.
Let it
Fine.
come.
My lord, only one thing, my lord, on last,
There are contradictions.
my lord, on last occasion, my lord, our name is not appearing in the order sheet, my lord. We are present.
Come back, give your names, give your names.
And only one thing, my lord, kindly supply copy of.
Even your name is not appearing. You are appearing today for the first time.
But on the last occasion, my lord, I appeared, my lord, but our name.
I'll record.
And man, the copy of the
Inadvertent-
timetable and permit of the petitioner that has not been annexed, man, let them supply the copy.
Sir, I will check it
Because
up and I will.
Where it is classing.
Please
Because
find
time-
out if you want, yes, that has to be found out. Please come with a supplementary affidavit if you want. Inadvertent error has crept into the order passed on 16th August 2023. Paragraph in the said order, the names of, please give your names in the earlier order also, state. Mr. Bandyopadhyay আর ওনার নাম
এইরকম পুরো পিটিশন লিখে লিফট করেছে এখানে দেখাচ্ছে আমি তোকে
he
বেরিয়েছি
recorded as learned counsels for the state respondents.
তুই শুনলি তো সব
আজকে যে দুটো নাম থাকবে সে দুটো নাম হবে। Paragraph, the department is directed to make necessary correction accordingly. Paragraph, this order be treated as part of the order passed on 16th August 2023. Paragraph, on prayer of paragraph, the petitioner seeks to take instructions in this matter. Paragraph, let the matter appear under the
and
same
if necessary we not file supplementary affidavit if necessary
this matter and paragraph matter stop there. On prayer of the petitioner,
because I am
liberty
also
is
confused.
granted to use a supplementary affidavit, comma, if required. Paragraph, let the matter appear under the same heading on 18th September.
Because I am also confused.
Next. Oh,
But
hearing
only one,
matters.
Malad, only one indulgence may I, Malad. Item. Malad, item 276 of days this, Malad, tomorrow it will not be taken up. Malad, at least Friday, because Malad, this, my vehicle will be confiscated, Malad, by this.
The list will continue on Friday, no difficulty. List will continue on Friday.
There is, Malad, division that I don't know, Malad, whether.
No, Friday there is no division bench.
Let it be then,
This Friday there is no division bench.
so that this matter can be taken up,
I'll take up the list on Friday.
because this vehicle will be confiscated in that event, Malad, this is very
Please come back.
fine.
78.
Well, I'm for the state responsibility. 278 আমাদের
দিদি তার আগে একটু 271 টা ডাকুন তো সেম
আচ্ছা, আচ্ছা,
রিকশা
ঠিক আছে,
ম্যাটার
ঠিক আছে।
ওটা ডিসপোজ অফ হয়ে যাক 271 টা একটু ডাকুন Mr. Khan, you are in 271.
Same matter, I need to.
Yes, let it be disposed of. 271.
Yes, terms I mean.
271 state.
Mr. Amol Kumar Sen is appearing for the state. Mr. Amol Kumar Sen is appearing for the state respondent.
Let the same order be passed.
Same order.
Ashu. 271 Rajiv to bola আছে same order.
As item number 262. As item number 262 as same.
62 Rajiv to bola আছে 271 order করবে
271 টা হচ্ছে কি?
271 আছে।
Same bol.
My lord, in 271, I have some submission, my lord. My lord, the writ petitioner is defendant in the pending title suit page number 94. My lord,
Next.
একটু রেকর্ড করিয়ে দিতে হবে জিনিসটা। My lord কে জানানো দরকারই ওটা।
Hearing matters.
Great.
78.
পরে ধরো ওদিকে যে আমি অ্যাপেলেন্ট আমি পিটিশনার তোর ওদিকে যা।
Mr. Banji.
I'm grateful, deeply obliged, my no, I'm not an old man.
I know that.
So I'm really convey my gratitude, not to praise. I mentioned my lords kind enough to pass the order matter to appear. Matter appeared. আমি তোমাদের কাউকে কিছু বলবো না। The reason
Yes,
the
respondents.
I appear for the National Highway Authority, Your Lordship.
তুমি অ্যাফিডেভিট দেবে কি ফাইল করেছো? Well, reason for which I am here to knock the door of the temple of justice. Naturally, my lord, since there injustice that has been done on me. Certainly, my lord will ask Mr. Manager, what is injustice? Because the door is open, everybody cannot come and we cannot entertain anyone. The my lord, it has got a history, my lord. History is this, my lord. I appreciate, my lord, that there is no doubt about it. Unless some power is given to the authority to take the land. Naturally, in the country like India, my lord, government or any authority cannot compel a citizen to transfer the land. No, I'm not interested. Then what is that? As my lord knows, there is eminent domain. So eminent constitutional domain is there. Right from the 1892, my lord, and onwards, land acquisition, then this act, this authority can acquire the land. So I don't have any grievance about that. I cannot rather. The question is, my lord,
land was acquired for a certain purpose. What is that? For a road. Very well. And for ancillary purpose. Because certain works to be done. So some materials, stacking of materials and machineries, another land is needed. Maybe it has got no direct nexus or direct connections with the construction of the road, but indirectly it is needed. So my lord, some land was also acquired in this, which is little bit far away from the proposed or the at that time it is proposed of the highway. Very good, no problem. So highway is complete. We are there. We are there for quite a long time. Why I am saying, my lord, the plea which I will take, my lord, is very vital. The question of adverse positions. So we are there. We have been paying the tax and other things. There's a problem. And the most interesting thing is this. If the purpose for which the land is required or acquired is completed, whether the authority can retain their land any further. Suppose today, for the purpose of road construction, a land is taken. But instead, by the side of the road, constructed road, some other lands are there. That was not needed. For the widening of the road, in future, they may say, I need more land for the widening of the road. Then you'll have to initiate a fresh acquisition. Naturally, on the basis of that acquisition, you cannot proceed. So naturally, my lord, and primary object to construct the road, and secondary to assist all those people who are constructing the road or stacking the materials, machineries, another plot of land or 2-3 plot of land acquired. So once at the cost of reputations, the road is completed, do they require any further that particular land where I am staying over there? I say no, they cannot. Even if they take the piece taken, but the widening of the road it is needed, that you can't do. Because purpose for which land was acquired, that is complete.
You are admittedly occupying vested land.
Yes, I cannot say it's a vested land, but still it is a vested. But anyway, for argument's sake, let us accept the vested land. Acquired land, I cannot say vested land, my lord, subject corrections, my lord.
Upon acquiring.
Yes, absolutely, my lord, absolutely, my lord. So, my lord, admittedly, we are there. We have been enjoying this property. Some, my lord, persons, they thought, benevolent. Then, no, for what in the road is needed. Authority never did it. They certainly move a writ applications, public interest litigations, before your lordship's court. The bench of the public interest litigations, they say, no, it can be done. And if you want to do that, you apply your section 26. I come to that section, my lord, 26, to remove all these quarters, other things. So the case which was made out by them before the Public Interest Litigation Authority, High Court, they say for the widening of the road, the land is needed. I was not made a party. I was not a party there. Of course, other side or my lord can ask me, Mr. Manager, how is it? When the appeal or public interest litigation, then the order which is passed by the court, it is a judgment in rem, not judgment in personam. If it is judgment in rem, whether you are a made a party, I am arguing against myself. If it is a public interest litigations, so even if you are not a party to that, you are bound by that. And very well, we didn't stop there. You went to Supreme Court. The Supreme Court in his wisdom thought it no. Certainly have a right. You can challenge. You approach them, you can challenge. Not only because of the not service of notice, but also if you show that, well, by this time you have accorded substantive right, certainly you can challenge. Nothing more, nothing less. So 26 will not apply in your case, but we are not passing any order. We are giving in the liberty. I got the liberty. Then I came before lordships. Let us read my list of dates to explain this, which is at page 4. I'll place the list of dates for your lordships' convenience. Fine.
Yes.
Have you got it, my lord? 21st December 1962. Kindly see the year 1962. the possession of 119 decimals of agricultural land and Danga land. Once you say agricultural land, then somebody must be there to cultivate the land. And Danga land of Feluchor and Ghosh and others comprised in RS plot, Puja Southern Sat, Jamju was requisition for stacking yard for supply of bricks and pads for substation Alampur will be any 6. Kali marked it, my lord. This is very relevant. So the object and purpose for which you was taken, if it is fulfilled, you cannot, if you really interested to acquire the land, again you have to initiate proceeding. That is the purpose for which you is taken, not any other purpose. It is indirectly related, but not directly to the land. Land acquisition case being case number Sansan, and the said possession was taken over by the Land Acquisition Department of Government of 21 December 2022, and a total quota of 105 decimals of land was acquisition for that purpose. The construction of National Highway was completed prior to 1970, that's really marked in Maila. And the major portion of land is lying unutilized by highway divisions since then. In certain portion of the said plot, the petitioner is cultivating, and rest of the same are lying barren, as the same is not fit for cultivation. The major portion of the same has already been released. Kali marked in Maila. It's very relevant. Though it was at that time, but subsequently on Supreme Court judgment, I'll cite that. Very elaborate discussion by K.M. Joseph, sitting on the judge. What is the duty of the authority? Can they retain the land? Because that was the earlier concept. Once the land is acquisition, there is a scope for requisitions. Once it's vested, can be divested. That is absolutely been ignored by the Supreme Court because no, that can be the law and clarified. And the next day, with the following, I give one copy to the lordships and I'll read it. Already been released by the collector in favor of these and owners. And at present, the said acquisition force of land are being utilized as go down petrol farm. Gadget. So, my lord, some portion has been released. What's wrong? I have committed, my lord, if I am similarly placed. Why it was not done? Now, Gadget notification 65, number such and such, under section 1A, section 4 of the West Bengal Land Acquisition Act 1948, since expired for the public purpose of providing facilities from transport and communication for stocking yard for supply of bricks and bats for substation in that system. Then 94. Representation made by the petitioner in interest of the petitioner, Feluchor and Ghosh and others for release of unutilized excess land acquisition NH6 by the government of West Bengal under Act 248 before the school engineer and the director of executive engineering division, and the same was received by the respective office in Sansa, copy of which was sent to the Secretary Department, the Public Department of Commission. This image thousand. Kindly pause here for a moment. As my lord knows better than my lord also with vast experience on that side. 12. Previously, my lord, this Act 2 is not a permanent act. So, my lord, 1 year, 6 months have to extend it. So that matter appeared before Justice Sophosati Mukherjee has resolved in the Supreme Court. Even a drastic remarks. How is it? If you need it, you acquire it. This is not the way to do that. So, my lord, now I cannot deny that 12, though it was a temporary act, it was according to that act, but since subsequently the entire scenario is changed to amendment of this provision of that, it is acquired. So that part is I cannot challenge, my lord, I must frankly confess. Then 94. Application made by the owner of the land, namely Feluchor and Ghosh and others, praying for release of the land before the executive engineer was duly recommended by the local panchayat, which is relevant. They are actually work as the grassroots. So panchayat form that was in the 1994, my lord, not today. So they found that unnecessary it is being under the acquisition, so-called acquisitions. So they recommended, yes, it can be done because their consensus that was done. Previously, that was done. So to avoid any future complication and to save their face from the court of law, there's a very little can be done. Now, 91. By memo number such and such, the special land acquisition officer informed these and owners, said Feluchor and Ghosh and others, that the application made by them had been forwarded to the executive engineer, Howrah director, to know their views regarding release of plot of land, to restore the land and a formal proposal for the relinquishment along with the 4 plan showing the plot of land to relinquishment. My lord, the process is very interesting. So they also inquire whether it can be done. Not that, my lord, no. I am saying once it is basically divested. So get out. Enough is enough. They also considered and they wanted to consider from the higher authority. The 90 letter written by the learned advocate of the KM landowners, namely Felucher and Ghosh and others, requesting to release the land in question and to take step in matter as an early date. 1995, once again, first 10 January. Felucher and Ghosh and others, the previous owners of the land in question, affirmed a writ application and the filed the before the Honorable High Court, Calcutta. Order passed by the Honorable High Court, thereby, upon disposing the writ application, my lord, this part is very interesting. Kindly see. My lord's courts, my lord, entertain the application, or writ applications, at the cost of reputation. Order passed by the Honorable High Court, in thereby, upon disposing the writ application, his lordship, the Honorable Justice N.K. Mitru had been pleased to direct the authority concerned to consider and dispose the Annexure C to the writ application in accordance with the law. After hearing the petitioner and taking into consideration the document and papers to be filed at the time of hearing, and by passing a reasoned order until such date of disposal status quo as on date shall be continued. Kali mark this one very significant. So even today I am protected by your lordship's court's order, the status quo. So this authority, without giving respect to this order, started proceeding, issuing notice. Why did you not ask the court? No. Kindly vacate the order of status quo. Registered deed of conveyance by which the petitioner government pattern purchase such and such correspond to such by separate to registered deed of conveyance. Here my lord can ask me one question. I must finally confess. Personally, how is it? Yes, you made a representation and is there considerations. So how we can purchase it? Now, my lord, my root of this, starting with the argument, it cannot be retained. So that's why I purchase. And whatever order to be passed in future, if it is de-requisition, no problem. If it is not, subject to result of that proceeding, my purchase will depend. I must frankly confess. Rise and fall of this, my representation is pending. So now they cannot say that, please, no, you have purchased, how can you purchase that? No, purchase illegal. No, bhai, it cannot be. My purchase is illegal. It will be void. If it is found that well, it cannot be done.
It's at your risk and peril.
My lord.
It is at your risk that you have purchased.
I am deeply obliged. It is my risk, sellers purchase, no problem. I can do that. Then, petitioner Gogun Patel purchased 30 acres of land, Korsuru Sajan. Petitioner Gogun Patel purchased 0.5 decimals corresponding to Sajan. Gogaben Patel sent an application before the collector, land acquisition, Howrah and district magistrate Howrah. The additional district magistrate, British land and land reforms officer Howrah. The special land acquisition, the superintendent engineer highway, national highway, and executive engineer national highway division PWD, praying for the requisition of the land which was requisitioned in LA cast number such and such for purpose of stacking years for completion of the national highway, and ultimately the project has been complete and presently the said land has not been utilized for kindly pause here for a moment. So I, without taking any risk, yes, my vendor did it. Still again I made a representation. By please relinquish the land, because purpose for which it is gone. So what right you have got? You cannot retain in this way, because acquisition is a limited power. Based on eminent domain power, they acquire the land. Suppose acquisition is cancelled. I wanted to construct a housing complex. Certainly, court can, statutory authority can do that. Government can do that. But if the scheme is cancelled, acquisition will cancel. Maybe cancel, then it cannot retain. Then private respondent affirmed the application and filed before the Honorable High Court, being number without making party to the occupiers of the land, although complaint was made against the petitioner. That is why, my lord, Supreme Court took exception. How is it? You are lodging a complaint against Mr. X, and Mr. X will not be heard. So because very early, go and challenge. No problem. The Honorable Chief Justice, the Honorable Justice Rahidullah Munsi, pass an order taking into account the complaint made by the petitioner in the said writ application that the National Highway Authority is not taking step for removal of the unauthorized occupation from the plots of land which were acquired by the government for entering the National Highway by being number such and such, directed issue notice under section 26 of the control highways. Kindly process. Each matter is irregular. First thing, what is unauthorized? It's very significant, my lord. Suppose today, that's why we started with this. I am in a possession in a land. At first, without permission. Nowadays, my lord, that delivered judgment, so many cases that well, even a permissive possession case, adversation can be claimed. But anyway, I am not going to that. I am there. I am there. You know that. I exercise all my right like a owner. And I have accorded certain right.
Mr. Ganesh, you will take some time to make your.
Yes, my lord.
So shall I release the other?
আর মাইলট হার্ডলি 15 minutes তারপরে আমায় বলবেন না 4 minutes যথেষ্ট
No, I will in that case release the other matters for the day.
yes that might can be
Only the very next matter is mine and the 279 and 280 I am covered by your lordship shown Jarvin very recently your lordship.
তবে আবার কি মেরে
Kindly fix a date period because on Monday 4th is the releasing of the monthly list. Any day if you lordship kindly fix the time so here also is a.
I'll consider excluding the daily list matters from the monthly list. So that the daily list matters appear.
It is expected
I
that
will-
6th is the holiday.
I will
6th is
not
the-
include the daily list matters in
The
the
monthly-
monthly list.
Lordship.
Let the monthly list be as it is. Supplementary list matters will not appear on the monthly list day. Please do not get disturbed. It will appear on the next day.
Yes, yes. I'm grateful.
Monthly list day, let only the monthly list matters appear. I do not want to include the supplementary list matters in the monthly list.
So it is.
Because again, you have to mention it has to be
Yes,
taken in the
this is the whole,
supplementary list again.
this is the whole problem.
Ready?
এই ডাকছে
এটা বলেছি। I've already given instructions.
এরকম হয় না আগেকার দিন আমরা দেখি যার সাথে তোমার দিদি বলে সম্বোধন করছে
Other matters do.
দেখেছো আগে তোমার তো অনেকদিন হলো কোন
My
যার সাথে
tension is over.
দাদাবাদি
You will be remaining
ভেরি
there.
গুড থিং
Your tension
Huh?
is over.
Lordship,
Yes.
এটা তো সস্টের করতে পারো না কতটা সম্মান দিয়ে তোমায় ডাকছে ইজ এ জাজ
Yes, continue.
Yes, my lord. So, my lord, this is the whole thing. Kindly come to then 15 December 2017. The Honorable Chief Justice and the Honorable Justice Saidullah Munshi passed an order taking into account the complaint made by the petitioner in the said deed application that the National Highway Authority is not taking step for removal of the unauthorized occupant from the plots in question which were acquired by the government for widening the national highway being number such. This is a totally wrong contrary record. Two purposes are different. One is really for the construction, the other is for tracking the material which is needed for the construction. High Court directed to issue notice under section 20 of the control order as that from removal of the encroachment from the land belonging to the national highway. Notice under section 26 of the control of the national highway land has been issued in the name of the petitioner by the GM Project Sansad. SLP was filed challenging such order dated such and such. Kali marked it, my lord. Because there is an order of division bench. So as in whatever they have done in compliance of the, they will take the plea. Whatever we have done in compliance of the division bench order. So we have got no other alternative. Authority will say, we have served the notice. We don't like to face the contempt. Now, once the notice is filed, we went to the special, we move to special petitions. Then, can you see? The Honorable Supreme Court dissolved the said SLP. By following order, upon hearing the council, the court made the following order. Permission to file a special leave petition is granted. Heard the learned counsel for the petitioner, peruse the division delay condoned. As a learned counsel appearing on behalf of the public interest litigation, kindly see who is making the submission. It's not me. It's very significant. As a learned counsel appearing on behalf of the public interest litigation, petitioner has made statement that in the meantime the petitioner have been evicted. Pursuant to the notice, a totally false statement has been made by the. If I am really evicted, why should I bother the court? I could have filed a suit for damages and other things. Petitioner made a false statement there. The petitioner have been evicted pursuant to the notice issued in terms of the High Court order. We are of the view that the petitioner should be left to the remedy to approach the High Court for such appropriate order as may be considered necessary. Kali marked it, my lord. Very interesting. Here they, without making me party, moved with a frivolous statement, false, if I may permit to use this harsh word, false statement, which is dears the spirit of law. Court passed the order, matter went to the Supreme Court. There they made a statement that, well, position has been taken. So he's impetuous. Then, in spite of all this thing, kindly see the reaction of the Supreme Court. Supreme Court could have said, Supreme Court thought there is some mistake somewhere. Supreme Court, that is why, never say your appeal of the celebration is infructuous. Go and file a suit for damages. Supreme Court consciously says that, well, the petitioner, the High Court, we are of the view that the petitioner should be left to the remedy to approach the High Court for such appropriate order as may be considered necessary, especially petition and disposal. So this appropriate petition or order, that is why you have the objections. And my lord, kindly see, it's very serious aspect, my lord. Who are they? What prevented them to implement the party? They have got some private vested interest, because in the affidavit it is admitted we have not been evicted. So who are you to say? What authority you have got to go up to the Supreme Court and made a false statement over there? I could have filed 340 applications, could have addressed 340 applications. But see, there are some vested interest parties who just want to do some mischief and to grab the property. That is their whole intention. That's why I face the problem. I am knocking the door of your lordship, my lord. Please protect me. Now, what protection I need? First thing, my lord, if your lordship kindly. Now, my writ petition starts from page 5. My lord, it is a question of my livelihood. So that's why I'm disturbing your lordship, my lord, in details. Because case is really, my lord, went up to the Supreme Court, the divisional judgment, unless I assist the court in a proper way. My lord, you say, Mr. Banerjee, you have failed to assist me in proper way. Why did you not discuss all these other things? So that my lord, kindly take down to paragraph 2 of page 5 of the writ petition. Have you got it, my lord? Paragraph 2. Yes. Starts with that the instant deed application is preferred pursuant to the order dated 11 January 2019, passed by the Honorable Supreme Court of India, thereby, while disposed of the said special leave petition, upon observing that the petitioner should left to be permitted to approach the High Court for which appropriate order, for such appropriate order as may be considered necessary against the impugned notice dated 30th November 1928 under section 26 of the Control of National Highway Act such and such, and issued upon the petitioner for removal of the petitioner and also purported demolitions of structure lying and situated over plot number such on the allegation made by the private respondent complaining that the National Highway Authority is not taking steps for removal of the unauthorized occupier from the plots which was acquired by the government for widening the National Highway number 6. There also might not be a false statement. Although such land was requisitioned by the government of West Bengal by notification dated 1st December 1964 under the West Bengal Land Acquisition Act 1948, now expired, for the purpose of providing facilities for transport and communication by stocking yard for supply of bricks, bats, for substation, Alhampur area of the National Highway number 6 in the district Howrah, and such lands have been lying unutilized after completion of the period more than 50 years. Can you mark it, my lord? 50 years from the, why I'm saying, my lord, I cite when I said the judgment of Justice Joseph. I'll point it out, my lord. If it is not used for a long time, that's all. You don't need it. Special act is there. Under the special act, you are authorized. You cannot misuse. Suppose urgency under Land Acquisition Act, 56 old act. 17 is there. So showing that urgency, you acquire a land, deprive a person from his constitution, statutory right, 5 capital 5A. Now after 20 years, you are lying vacant. Oh, hurry, how is it? So here, my lord, 50 years, it's not being disturbed. Only they came and they just, in Bengali, what is called, Kuchiye gha kora. But they are their intention. Some mystery is there. 50 years from the date of acquisition of the said land, the sum of the then owners of the land applied for releasing the said land and the collector land as such, that is such forwarded such application to the executive engineer for submission of a proposal for releasing the said land, that as no action was taken, his application was moved before the Honorable High Court Calcutta on Sunday, and the Honorable High Court directed to dispose of the Annexure C to the HPC in accordance with the law. After hearing the petitioners and taking into consideration the document, and till such date, status quo to be passed. But till date, the same has not been considered. Very funny. You are entertaining all those imposters, stranger, and you are depriving us. They have got nothing to lose, only to gain. But in spite of such notice was issued, and action was taken, though the petitioners are occupying the said plot of land upon purchasing the same by registered deed of conveyance and upon including their name with the land revenue records for more than 30 years. Kindly marked it, my lords. We recorded our name, we paid the taxes, we exercised our right as owner for more than 30 years. So under the law, if it is private 12 years, but government is 30 years. I'll start judgment to that. That your petitioner state that originally one Girish from the GHOSH and Hori GHOSH was a possession of 60 days of land, police station, both of them. This one. 6. Subsequently, the Saurabh Chandra GHOSH. I've just given the history, my lord, how and when. On the GHOSH, Pratima GHOSH and others. Wife of the person GHOSH. The my lord, with the losses, kindly leave my I can skip over. Because these are the, like in the deed, my lord, nomenclature.
Yes, yes.
Amuk Chandra, Amuk Malik, Tapar Amuk Hol and the
This is not really very, not
very not very important.
It's a derivation of.
So kindly example to come. Paragraph. No, paragraph 14 is also interesting. Page 13, paragraph 14. Substitute losses correction.
Yes.
That your petitioner states, page 13, paragraph 14. That your petitioner states that while the petitioner interest of your petitioner is in possession of the said land by notification, said land was requisitioned for the purpose of construction of bricks and to supply the same for the purpose of construction national highway, and after completion of the project for the purpose of which the land was requisition, the said land was restored to the predecessor in respect of the petitioner, and since then, initially the petitioner interest and subsequently the petitioner by virtue of the purchase of the said land were possession of the said land for more than 30 years, as the land was requisitioned in the 1965, and thereafter upon taking possession of the said land, petitioner interest was in possession of the land since 1965, and after purchasing the same, your petitioner became the owner of the said land, and more than 30 years has elapsed. Relevant. More than 30 elapsed, but neither the government of the West Bengal nor any other authority disturbed the possession of the said land, and your petitioner running our business. My lord, this is to my knowledge practically. And before the Supreme Court, what this stranger submitted, possession has been taken. It is unfortunate, my lord. They are the person who are putting the thing, sitting behind the scheme. That your petitioner states that after purchasing the said plot of land, your petitioner duly meted her name in the records of the block land and land use officers, regularly paid their property tax, copies of the record of rights, and stand in the name of the petitioner. My lord, as my lord knows, my lord, record of right means it shows I am in possession. Of course, it has got a presumptive value, but still, unless it is reverted, that means I am in the owner and possession. That your petitioner states the government of West Bengal for the purpose of providing facilities from transport and communication for stocking yards, for supply of bricks and bats, or for such subsection Alamar Almeria National Highway number 6 in district of Howrah, requisition the said land along with their plots of land and thereafter by gazette notification section 4 of the Land Trust Act since expired, which was published in the official gazette 1965. A copy of such gazette notification that your petitioner states that the said land was acquired for the aforesaid purpose of supply of bricks and bags of substation district Howrah and completion of the construction of substation Howrah 6 the district Howrah. The said land was no longer required. Kalimakti Maila. If I require certain land for a certain purpose, if purpose is gone, you don't require anything. You have not purchased the land. Not that you have purchased by operation of law, by requisition for a certain purpose. And this was no longer required for the national highway as the said land is lying and situated far away from the national highway number 6. I have to annex the map. Can you mark it mine? For widening the road, it cannot be used. Even after widening the national highway 6, very recently, and the said land, my road has already been widening made. Even new position of the road, my land is far away from that. Recently, and the said land is using for your petitioner upon making construction over the said land and running the business of sawmills, and from the sketch map, it appears that the land used by your petitioner in far away from the National Highway 6, and the same is not at all connected with the National Highway. Your petitioner scheme need to produce a copy of the sketch map showing that certain site. Then, that your petitioner states that since the said land though acquired by the government of West Bengal, but after completion of the project, the said land was possessed and or used by the predecessor interest of a petitioner, namely Feluchan and Ghosh, since this is and the others, and since the said land was no longer required by the government, as it was acquired for a specific purpose and not for winding the national highway, and since such land is lying far away from the national highway 6, the predecessor interest of a petitioner, Feluchan and Ghosh, and his others co-sharer made a representation on 12 May 1994 for release of such unutilized excess land, which was acquired for the purpose of providing facilities from the substation for stacking the years of the supply peaks and such. People, sole engineer, director, and executive engineers and such. The same was received by the office and copy of the such development organizations. A copy of the representation PP4. I'll come to the later. That your petitioner said that subsequently the special land acquisition officer informed the then owner of the said land, namely Feluchan others by such and such, that the application made by them had been forwarded to the executive engineer PWD, Howrah Directorate, to know their views regarding release of plot of land to restore the land, a formal proposal for de-requisition along with 4 copies of plan submission, a copy of the said memorandum. That your petitioner states, in spite of it, government did not take any initiative to de-requisition of the land and of the release of the land, said land, as the said land was no longer required for the purpose of national highway, and as such, the predecessor in interest of the petitioner through their land advocate made representations that the petitioner states that in spite of such fact that the said land was not required by the National Highway Authority, but the concerned authority, though initially took step for releasing the said land, but subsequently sitting tight over the matter and no positive steps were taken, the Feluchan Mohammed and Sajjan did application. Your petition, that your petitioner said, ultimately the aforesaid did application. After they came up for hearing, Lord Judge N. K. Mittu, which have already stated, my lord, the Honorable Judge N. K. Mittu was pleased to dispose of the matter and says, consider nothing has been done, status quo still there. How they can make such a statement with the Supreme Court? Position has been taken because court has protected my right. Paragraph 23. That your petitioner said that by virtue of such order, since the concerned authority did not take any step to consider the matter as directed with the High Court, however, by virtue of such order, your petitioner was contrary questions and constant factor in there. That your petitioner said that thereafter, but I am earning my livelihood by running a business over there. Authority could have demolished, could have asked, hey, what you have done? Huh? You can do that. They allowed us. That your petitioner said thereafter on 28th October 2015. Your petitioner sent an application to the collector land acquisition Howrah, the special land acquisition officers, the superintendent engineer highway national highway, and executive engineer national highway division, praying for the requisition of the land, which was requisition such and such for purpose of stacking years for completion of the national highway. Ultimately, the project has been complete and presently such and such. That your petitioner said that while the matter stood, thus all on a sudden, notice highly marked in mind. How they can issue me the section 26 notice? I could have understood they have considered my application rejected as status quo is vacated. Status quo means status quo as a whole. Even the initiation proceeding for eviction and eviction, both are against that order. It's a nullity. At the teeth of injunction, if any action is taken, that is a nullity. That your petitioner said that while the matter stood thus already sudden, a notice of this was served upon your petitioner by reference number such and such. Thereby, the concerned authority directed the petitioner to review all encroachment unauthorized structure from the state government land within 7 days. Section 26. Or unlessly may be imposed by the petitioner recovery of consequential cost. That your petitioner says after issuance of the said notice. However, for the first time, your petitioner came to know that the private respondent affirmed a writ application, public litigations. I do not know if anybody is appearing for the private respondent here. I do not know. If they don't appear, this is more dangerous. That means they are avoiding their responsibility. They are the person as whose instance the High Court passed an order.
You implemented them as parties?
Kindly see, I have mentioned in the petition.
But they are not parties to the petition.
You have not implemented them as parties. How will they appear?
That you are right. That you are. I'm being unconditional apology.
If you do, you want to implement them as parties?
Yes, my law is absolutely up. My law is always right. If his order passing my favor.
Since
Anyway,
you pointed out that you need
that's two minor.
should be heard in their presence.
That's two. Very well. Keep. Very short time করে ফেলো তাহলে সবাই অ্যাড্রেসের নামগুলো আছে তো ওর রিপিটিশনই তো পাবে
How many private respondents?
ওর রিপিটিশনটা বার করো তাতেই আছে everything at their instance and when the authority appeared they ought to have pointed out.
There are 24 writ petitioners, your lordship, in the other writ petition.
তুমি এটা করতে গেলে
আমি তো আমার affidavit opposition এর writ petition টা annex করেছি।
ও এই তো 146 writ petition annex করা আছে okay in the writ petition we have annexed but they are not a party
Serve all 24 people.
তবে তাহলে সার্ভিস yes I will do that. My fault.
If you think they are necessary, then let them be added. Because any order passed in this writ petition will affect them.
One thing is very clear, the plea which I have taken that I was not a party, simply they will come and say,
Absolutely.
and unless they will disturb your lordships. Unless you will disturb their
So
lordships.
let us finish it off once and for all.
My lord?
Let us deal with it once and for all.
Yes, party to me, yes.
Yes. Will you give the details so that I can record it?
Lordship, in my affidavit in opposition,
Stated?
Page 127.
oh, in the
In
paper,
our petition also.
paper book এ বলছেন। না না,
কার হয়ে আছিস? হ্যাঁ?
state
আপনি ওই কর্নেলি আমার শিষ্য হয়ে গেলি বাহ চমৎকার very dangerous মানে now I'm saying আপনার শিষ্য কর্নেলি
127.
page 1, Lordship, 126 of the paper book, the writ petition starts.
the writ petition itself is a election here 126 আরে গভর্নমেন্ট বিল হয়েছে ভুলে যায় না
And your lordship, in the
ওই জন্য
affidavit,
সমস্ত
affidavit filed on behalf of the National Highway Authority, page number 20,
ফ্রাঙ্কি থাকো
page number 20, your lordship.
হ্যাঁ বা কি বলছিস হ্যাঁ করেছি তো ফাইল করা আছে তুমি ওটা জমা করো।
Page number?
Page 20, Your Lordship.
কাছে, কারণ যখন শক্তি
Page 20 of the affidavit in opposition filed by the National Highway.
আগে hearing করতে। এটা compilation.
Manik Chandra Bera, these people.
Well, as such, this
These
is
were the
not
petitioners.
paper compilation.
So there are 24 of them.
Lordship.
24.
জয়ন্ত? 24 জনের নাম আছে এদেরকে add করতে।
ওদের address
So shall I record that?
Yes, my lord.
Oh, I should have.
I cannot put myself in trouble because even if it is passed in my favor, immediately they prepare an appeal and unnecessarily condemn the court. Because my lord will not get any chance to say, Mr. Banerjee, suppress that. He will not get this.
Heard learned counsel for the petitioner. Paragraph,
ওদের মধ্যে
on
করবো।
prayer of the petitioner, liberty is granted to implead.
কদিনের মধ্যে এক সপ্তাহ?
Ponchanon Bera and 23 others, এখানে এবার হচ্ছে। Ponchanon Bera and 23 others as respondents in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly to do the necessary amendments. Paragraph, the petitioner is directed to serve a copy of the writ petition along with annexure thereto upon the added respondents and file affidavit of service on the adjourned date.
Within a week?
Paragraph,
Within a week?
within a
Within a
week.
week, yes, because my urgency is mine.
Paragraph, let the matter appear under the same heading on September.
As your lordship, my lord. Since I have already started, keep it as a part of my lord, otherwise.
Can you complete service by 11 September? You have to send them.
I'll try my level, গরজ আমাদের।
Shall I give you another week?
আমাদের কি করবো? একশো করে
Shall I make it 18th?
কোনটা? কি বলছো?
24 persons, please keep in mind.
My lord, instead of 11,
18th.
18th, yes.
18th.
And instead of 7 days, make it 10 days. Since that matter, that date is increased.
No, it is, I'm just fixing a date on 18th September.
As your lordship. ভালো করে বুঝে নাও কোনো কনফিউশন নেই, বুঝে গেছো? 18th কপি দিয়ে দিতে হবে। Same position, my lord.
Hopefully it will.
Otherwise, well, again, I'll come and disturb, my lord, my lord, my lord. দেখে নিন, চেক করুন।
Fairly at the top. Fairly at the top.
My lord?
Fairly at the top.
Fairly at the top.
এই রেকর্ডটা দেখে রেকর্ডটা দেখে